Mr. Conley, I've got double duty this morning. I got criminal arraignments and civil pretrials all sort of bunched together. And Judge Pattison is elsewhere. But we're not doing too bad, all things considered, if I get the jail booking to answer the phone.
They're buried in snow.
Maybe so. Well, give me a minute, Jeanette. I've got the record on, I got the live feed on, and I guess we'll just address this. Are you Brittany Clay?
Yes, sir, I'm here.
All right, I got a telephone only. I don't prefer that, but we'll do the best we can.
I couldn't get the meeting ID to work for the Zoom video. I'm not sure why.
All right, we'll do the best we can.
Is there any way you could have a breakout room, Judge? I haven't had a
Yes,
chance.
certainly.
Thank you.
This is file number 251565GC. It's entitled Three Rivers Health versus Brittany Clay. I don't have the entire file, but a default had entered in this matter in a substantial amount, $11,855. That default entered November 12th. On November 13th, we received a letter from Ms. Clark the day after the default entered. She didn't show up for the hearing, questioning the whole matter. We set it as a motion to set aside default. Mr. Robert Conley is here. He represents Three Rivers Hospital in a lot of their cases, and Ms. Clay is here. Ms. Clay, you didn't show up, or you didn't answer the lawsuit. You got sued, you didn't file an answer, and a default entered. The day after the default entered, you filed that letter. So you have 21 days after a default to move to set it aside. So I treated it as that. Mr. Conley is here, and he's agreeable to speaking with you privately in what's called a breakout room. So I'm gonna, hopefully you'll be able to go in there just automatically, and he'll be in a private space where you can talk with the attorney. And I'll be here working on other stuff.
Okay.
Good morning, Sergeant Ball. This is Judge Middleton calling. I got a bench warrant to see Jeanette Jackson. Wants to know if we can see Sivan Gowan. No, could I see Sivan Gowan? Okay. I figured something was going on. Oh, those guys are to blame. Oh.
As soon as I get a deputy freed up, you go and get Mr. Jones. I will work on getting it up anywhere from 5 to 10 minutes. They're off the box.
All right, we'll do the best we can. Thanks. Bye. He was gonna go get Jeanette, look for Jeanette Jackson to bring her out. I always used to blame it on Debbie. Debbie Davis says, we need to see so-and-so. But they were gonna go look for you in one of the cells, I guess. And a bunch of pens that don't work. That finished, we had about 18 people get arrested over the holiday weekend. We were at 92, I think, and we were at 207 this morning. It was so snowy and crappy. I'm surprised that people had time to get in trouble.
That's what I was thinking.
Mr. Gowan has multiple things. And more even than this. But we'll see him in a minute and then let you go. That was set for 8:45. And then I have a 9. There's several cases that I had hoped were going to settle. I didn't realize Judge Patterson was going to be gone. I was gone Monday, Tuesday. He was gone Wednesday. We were all gone, and he's gone today. So I haven't seen him in about 10 days. Here's the jail. Good morning.
Hey, Roger. Middleton, all that about.
I got an upside down chair. I'll put this in waiting room. Mr. Guy, 1958 SM. That's the MDOP. 252203. That's a retail fraud second. He's not going anywhere. Did you manage to get out of your driveway this morning? Did you shovel it out or did you have
I
somebody?
have some very, very nice neighbors who always plow me out.
Maybe they could come over to my house, about croak myself.
Well, the village did a crappy job because they left snowbanks. There's no way I could have plowed myself out.
Yeah, the road commission comes and plows the road and it puts like a cement frozen wall
Yeah,
of snow
yeah.
at the end of your driveway. Good morning, sir.
Good morning.
This is Judge Middleton. I'm here at the courthouse. With me also is Jeanette Jackson from the Public Defender's Office. You got several things going on. We're going to deal with them. Are you Savan Elisha Gowan?
Yes, I am.
You had a charge of domestic violence. You were set for a pretrial with the attorney Ross Truckee to represent you on Friday afternoon, this Thursday, December 4th. You failed to appear, he was set to represent you on October 30th. You didn't show up for your hearing on October 30th. The bench warrant issued and you got arrested over the weekend. When did you get arrested?
I was just brought in on Wednesday. I've been in rehab and I went on my own. I didn't tell anybody I went. Yeah.
Where'd you get arrested on Wednesday?
At my house.
On Fawn River Road?
No, I wasn't on Fawn River Road. I was on 300 South 4th Street.
Did they come there specifically to arrest you or did you have just some other reason to have contact with them?
They said they came there because I had bench warrants and they were shining flashlights in my face and told me to come out front.
All right, well, very good. Get the case back on track. I'm gonna set this for a last pretrial with Attorney Truckee. For this Thursday. He's set to be here that day, 12/4 at 2:00. Bond is now $1,000 cash or surety. You also failed to appear for arraignment in a charge of malicious destruction of property. Take a look at that. That is file number 251958. In that case, the allegation is that you were in the village of Colon and you had damaged some vehicle tires which belonged to Katie Brandy's, and you had been in a dating relationship. Injury of more than $200, but less than $1,000. I can attest, having just bought 2 new sets of tires, that a set of 4 tires can be well over $1,000. Anyway, that's the allegation. They allege that it happened on August 30th.
If I may, I did go in and replace all 4 tires. If that
All right, well,
means
don't say
anything.
any more about it. Show a plea of not guilty. I'm going to appoint Attorney Rhonda Ives. And set an attorney pretrial for January 1st. I can't go that far out. For December 19th. At 8:30. Bond in that case is also set by the magistrate at $1,000 cash or surety, actually set by Judge Pattison. He did show up for your arraignment. Where did you go to rehab?
In Kalamazoo at Enlightened Recovery.
What's the name of it?
Enlightened Recovery.
Lang's Recovery?
Enlightened.
Oh, Enlighten. Well, that's a plus. All right, then we got one more. File 252303. Charge of retail fraud in the 2nd degree. In that case, it's alleged you were at the Myers store on October 12th, and you stole some stuff, and you had a previous offense, making it a 2nd degree retail fraud. That's punishable by up to a year in jail and a fine of up to $2,000. Excuse me. Hoping before January 1, I won't be sick anymore. Gotta stop hanging around with little kids. All right, I'm gonna show you plea not guilty on that. Show plea of not guilty. I'm gonna appoint an attorney. Set attorney pretrial again for December 19th. At 8:30. If I code to December 2nd, it's more than 28 days from the day you got arrested. So I'm gonna accelerate this up to December 19th. So you got three, set bond at $1,000 cash or surety. You're not to go to Myers. When did you get out of rehab?
I got out of rehab on probably, I'm just spitballing here. I think it was roughly the 15th
Of what?
November. I went on November 3rd.
All right. Well, you never bothered to call your lawyers or the court or show up for anything. So now you're sitting in jail. Mr. Truckee represents you in the first case. We'll deal with that this Thursday. Maybe they can address everything on Thursday. The other two cases are set for a little later. That would be December 19th. All right, Mr. Gowan, you're good to go.
Thank you.
Thank you, Ms. Jackson.
All right. I think we're done.
I think so. All right, now we're going to switch back to civil matters. Jenny, I put all of Mr. Gowan's stuff on the same ROA. Good morning, Mr. Sayeg. We're in the middle of another case, and we'll address that first. We were in the middle of criminal arraignments and civil pretrials. We started our first civil pretrial, Rivers Health versus Brittany Clay. That was file number 251565. Brittany Clay is here and Mr. Robert Conley is here. Parties were put in a breakout room. Ms. Clay, can you hear me?
I can hear you.
All right. Mr. Conley, what's the status?
After Ms. Clay and I spoke, Your Honor, it seems like all she really needed was a payment plan, something that she could afford on this. We agreed on a payment plan of $100 a month for 6 months, then revisit starting January the 7th, 2026, and the 7th of each month. I went over where she is to send her payments. I've had a previous case with her as well on some other accounts, and she just really wanted a payment plan.
January 7th, 2026, subject to review after 6 months.
Yes, sir.
All right. Perhaps the way to do this would be to show a amended judgment with a payment plan. I'm going to show that upon review, the motion is denied. Defendant has agreed to a repayment plan. At $100 per month. starting January 7th, 2026. Ms. Clay, do you agree that the judgment may, excuse me, I'm sorry. I'll drop dead here. Remain in the amount of $11,855.84, and you're going to start making payments of $100 per month, starting January 7th, subject to review after 6 months. Is that agreeable with you?
Yes, sir.
At this rate, that would take 10 years to pay this off, not even counting interest. And so maybe it'll get amended at some point, but the original judgment will stand. Motion to set aside the default is denied. You've agreed to a repayment plan of $100 per month starting January the 7th. Defendant agreed on the record. All right, Ms. Clay, do you have any other questions?
I don't think so.
All right, very good. You're good to go. Thank you.
Thank
You've
you.
got instructions on how to make payments.
Yes, sir.
All right, you're good to go.
Thank you.
Mr. Conley, I think that order I did will suffice. It leaves the default judgment in place, but inserts a payment agreement. Our next matter is LVNV funding versus Justin Pratt. Attorney James Sayag was here. I just lost it. I think I may have deleted him. I went to remove Miss Clay. And Miss Alice, I'll be with you in just a moment, all right?
Okay.
And it's jumped and I kicked her out, kicked him out. Anyway, while we're waiting, let's call this case, Three Rivers Health versus Amber Ellis. Robert Conley is here on behalf of Three Rivers Health. Amber Ellis is here. We called this matter earlier on October 6th, and the parties were working on a resolution. The matter was adjourned to this morning. Mr. Conley, what's the status here today?
Your Honor, my client emailed me Wednesday evening, right before Thanksgiving, and said that she was eligible at that time. So they're just going to write off the balance, or I'm dismissing the case.
All right. Well, that's a blessing for you, Miss Ellis.
Yes.
Yeah, they were looking at the hardship eligibility, which is one of the matters that we continue, reason we continue the matter. Mr. Conley, I'd ask you to submit an order of dismissal. The claim was for $1,114. And once that's dismissed, Miss Ellis, this case is done.
Perfect.
All right. As he said, he didn't get that information until very last minute Wednesday. All right, you're good to go. Thank you, Mr. Conley. I think that finishes our business, doesn't it?
Yes, it does. Thank you.
All right, thanks.
Yeah.
I apologize, Mr. Sayag. I think I went to delete the other lady and she clicked off and it went up to you and I accidentally kicked you out.
Oh, no, I think that was actually on my end, Your Honor. I think we had like a little power surge and the computer went off and I just had to zoom back in on my phone. So that was on me.
All right, well, let's call this matter. It's entitled LVNV Funding versus Justin Pratt. File number is 2520GC. We were here previously in August, and Mr. Sayeg was here on behalf of the plaintiff. The defendant was here. We adjourned the matter for 60 days for plaintiff to file a motion for summary disposition and giving defendant time to answer, alleging that there is no material issue of fact and no defense has been stated. In point of fact, Mr. Pratt is not here. The problem is this isn't set until 9:30. So I can't hear it yet. Somehow it got set for 9 and 9:30, Mr.
Yeah,
Sayeg.
there's actually two matters with this defendant, Your Honor, and I had one on for 9 and one on for 9:30. So to play it safe, I just zoomed in
Yeah,
at
there's
9.
25948 and 2520. Well, let's just wait. How about if you just go about your business for a half an hour and we'll click in again. Let's see what Mr. Beckstein is here for at 9:30. $25948 GC.
My sheet says 25-20 GC.
Well, we're double booked because Mr. Sayeg is here
For
for the
plaintiff?
defendant, and you're now here. So I guess we can address that matter.
I'm also here for defendant Justin Pratt on 25-20-GC. So
All
we're
right,
here
well,
on
let's
the
take-
same matter.
All right, very good. Okay. We discussed this matter at some length back in August. Plaintiff has filed a motion for summary disposition. As far as I can tell, defendant did not respond. Let me make my notes here.
Take these.
All right, Mr. Sayeg, I apologize. I thought you were here for the plaintiff rather than the defendant. So I wasn't looking closely at my file.
Oh, that's no problem.
Anyway, the matter is set for this motion for summary disposition. It seems pretty straightforward. Mr. Benkstein, what's your position?
Our position is that defendant opened the account. This is a personal loan, Your Honor. Defendant opened the account, accepted funds, made payments, but then stopped paying on the account. Defendant has not demonstrated that there's any material issue of fact in dispute, and plaintiff is entitled to judgment. I'm asking the court to grant our motion for summary disposition.
Mr. Sayeg, what's your position?
Thank you, Your Honor. Actually, I was hoping to have a breakout room with counsel before we got into arguing.
We can certainly do that. Let me set it up.
I'm amenable to that.
I had reached out to Max Quinn on this matter before the break, so I think maybe the emails didn't get sent where they needed to go.
All right, well, that's fine. I'll be here anyway. I'm gonna shut off the live feed and cough for a while you guys talk.
Hi, how you doing, sir?
Good morning, Mr. Funk.
Good morning, sir.
All right, I'm looking for Mr. Harris zooming in here. All right, so it says iPhone. Sir, what is your name?
My name's Allie Peters. I got the link to have a Zoom against Ryan Peters.
In a divorce case?
Yep.
You have the wrong Zoom number. This is Judge Gothier in Presque Isle County on a criminal docket today.
Okay. All right. Thank you.
Yep. All right. All right, sir, what is your name? It says iPhone.
Ricardo Harris.
Okay, very good. So we have People v. Ricardo Harris. It's file 25-93380FH. Counsel, you want to state your appearances beginning with People?
Dave Funk. On behalf of the people. Sorry about that. Dave Funk, P26715 on behalf of Mr. Harris.
All right, and Mr. Funk, have you had a chance to review the charging document with your client?
Yes, sir.
And do you or he wish to have its allegations read into the record?
No, sir. We'll waive the reading of it.
And how does he wish to plead to those charges?
Not guilty.
Do we have, that file? I don't have a copy of the information yet. Has the information been filed?
To my knowledge, it has, Your Honor.
Yes. See the complaint.
I have a dated copy for the 6th, Your Honor, or 26th, Your Honor.
Of the information?
Yes, Your Honor.
Do you have a copy of the information, Mr. Funk?
Yes, sir, I do.
It's not in the court file. Can you present one? I can't arraign somebody on an information that the court lacks.
My apologies, Your Honor.
So everybody's got it except for the most important part. The court's got to have the document to proceed here. All right. All right, we'll enter a plea of not guilty on Mr. Harris's behalf to 2 counts of assault by strangulation, count of child abuse 3rd degree, and 2 counts of domestic violence. Is a forensic center referral requested, Mr. Funk?
No, sir.
Okay, what would be the estimated length of trial?
No more than a day and a half to 2 days, Judge.
I would agree, Your Honor.
Yeah, very good. Funk appropriate for docket call January 5th at, say, 10 a.m.
That's fine, Judge.
Okay, and do you want Zoom appearances to be allowed for that hearing?
The defense would, yes.
Okay, any objection, Mr. Wergo?
No, Your Honor.
All right, so Mr. Harris, Mr. Funk, the docket call in this case will be scheduled for January 5 at 10 a.m. And Zoom appearances are allowed but not required then. All right, anything else from the people?
No, Your Honor.
From the defense?
No, sir.
Okay, have a good day, Mr. Harris.
Thank you.
You too, Judge.
All right. All right, good morning. What is your name?
Good morning, Brady Fisher.
Okay, so Mr. Vogler, this is People v. Brandy Fisher, file 21-93 or 93178FH. Here for docket call, and also we have the motion to reinstate bond and amend the conditions. In terms of the docket call, do you know what our status here is of the case?
Yes, I do, Your Honor. There's another case right now pending in the district court. There's been a plea offer made to us that basically wraps this case into that case.
Okay.
So we're not really ready to proceed here.
So you want me to continue the docket call to the January 5 docket?
Yes.
January 5 at 9:40 a.m. And as to your motion with bond, go ahead.
Judge, I don't have a whole lot more to add, other than, as I mentioned, there is a case in the district court. That is a felony case also. Her bond set in that case is $10,000, 10%. I think the most important thing, I recognize she was gone for a number of years here, but my client did turn herself in on court bench warrant, came up here with the aid of her sister, turned herself in. She is involved in the family court in Macomb County. She has an attorney there, Susan Dunn. And in that particular case, it appears like the Department of Health and Human Services would like to place, in fact, they would like to place the children with her. But I think the fact that this bench warrant was outstanding in this case was preventing that. So she executed a delegation of parental authority. The children are placed, I believe, with a relative, if I recall that correctly. She has a residence in Detroit where she's been residing this time. During the past 4 years, there's been a number of times where she has turned herself in downstate. Not that. One of the things too, I think is important is the fact that back in September of 2021, she completed a 6-week anger management course and has engaged in rather extensive counseling in Centerline, Michigan. And I think that at least goes to it speaks towards the allegations in this case.
Okay. Thank you, Mr. Vogler. Mr. Wargo, people's response.
Your Honor, I would note that defendant will be facing there as part of our offer. There's potentially not doing an absconding charge that would be forthcoming. If we're unable to resolve, I would be seeking remands to file felonious assault and child abuse second charges. Your Honor, this is a very serious case, and as to the allegations, Ms. Fisher is waiting in the wings for the kids. I'm pretty certain that once the department becomes aware of the specifics of the allegations in this underlying case, that's just not going to be an option. Nothing else, Your Honor.
So you're opposed to amending the bond conditions to remove the no contact? Am I hearing that right?
Yes, we'd be opposed to removing those conditions as well as any reduction in bond, Your Honor. She's facing a lot here.
Well, I mean, what I have in front of me is 2 counts of a 2-year felony. The defendant had posted a $10,000, 10% bond back in 2021, and then didn't appear. And a warrant was issued. She did turn herself in on it now 4 years later, so I revoked her bond pending this hearing. There's another felony pending in the district court, but it sounds like from both the people and the defense that there's a possible global resolution of the whole case. And I think looking at all of the factors of 6.106F, I mean, I think it might be appropriate to set a bond rather than leave bonds entirely revoked here. I would note that a $10,000, 10% bond was insufficient to secure Ms. Fisher's appearance before. So a personal bond would certainly be insufficient to secure her appearance. The court will set a $50,000 cash or surety bond with the same conditions. And at this point, Mr. Vogler, I'm not going to amend or remove the conditions. I just don't know enough about the underlying facts here. And I don't know whether the department downstate that wants to place the children with her is aware of these facts. I mean, if it may be that removing those conditions is going to be entirely appropriate, but I can't be confident of that today. So I'm not going to remove those conditions, but I will set a bond. And then we'll be next January 5th at 9:40 a.m. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Okay. All right. We'll see you then, Ms. Fisher. If you do post the bond, you have to be in person in court on January 5th at 9:40 in the morning.
Thank you.
See Mr. Williams and Mr. Harimoto on Zoom. Good morning, Mr. Williams.
Morning, Your Honor.
All right, up next, we have People versus Alex Harimoto, file 25-93378FC. Counsel, you want to state your appearances for the record, beginning with People?
Your Honor, this is a special prosecution assignment. For
Oh, that's right. That's with Miss Reed, and I see her. That's right. Hang on. All right, good morning, Ms. Reed.
Good morning, Your Honor.
All right, we're calling the case of People v. Harimoto, file 25-93378FC. We have Elizabeth Reed for the people, Mr. Williams for the defense, and the defendant appearing. All parties are appearing by Zoom, and I'm here in the Pressfield courtroom, providing public access both in the courtroom and also online. And we are here for a docket call. And what I mean by that, Ms. Reed, is that I treat that as sort of like a jury status conference. Is the case resolved? Is it likely to, is it resolved? Is there any motions that are going to be filed? Is it ready to be placed on our trial docket? Or should we set it for another docket call if the parties are still in discussions? So Mr. Williams, what's the status here, sir?
Thank you, Your Honor. I did speak with Ms. Reed this morning, and she did make an offer of criminal sexual conduct 4th degree with no other plea concessions was the wording. So I just want to be clear that was the offer. We intend to plead to the CSC 4. I would ask if the court could set this out for a plea date. I really haven't had much opportunity other than telling my client that the prosecutor did make the offer, but I want him to be very clear on what the consequences are. One thing that I have to look at, and I think because of the age, I do believe it will be a 25-year registry as opposed to the 15-year registry. So there's also some, and any motion work would just be either a sentencing memorandum I file, which isn't a motion obviously, or I know the prosecutor will object to it, but if I do file Holmes v. Trainee, she'll object to it. I don't have any leverage there because he's over 22, but I still may use this opportunity just to educate the court on the events that took place or through the sentencing memo. But we do have a resolution. We do not intend to go to trial. This is not a case that would go to trial based off of the evidence and the statements that have already been made through confession. So that's where we're at, Your Honor.
Well, what I could do is schedule this for another docket call on January 5th at 11 a.m. I would allow Zoom appearances for that hearing. And if you want to use that as a plea plea taking date, that's perfectly fine. And I'm comfortable even taking felony pleas by Zoom if you want to do that. If you want to be in person for that, that's fine as well.
No, we'll plan on Zoom, and we'll plan on doing a plea by Zoom. I think that's appropriate, and obviously we'll be there in person for sentencing, but we could do that.
Okay, well, we'll set it for docket call January 5th at 11 a.m. Zoom is allowed for all parties. Anything further from the people, Ms. Reed?
No, Your Honor, I just want to confirm, I do believe it's 25-year registration period.
Okay. All right, anything further from the defense, Mr. Williams?
No, Your Honor, thank you.
Okay, have a good day then.
You too. Happy holidays, you guys.
Thank you. All right, is this Mr. Chapman?
It is, Your Honor.
All right, this People v. Wyatt Chapman, file 25-93379FH. Counsel, you want to state your appearances, beginning with People?
Morning, Your Honor. Zachary McClendon on behalf of the people.
Hey, good morning, Your Honor. James Gilbert here on behalf of Mr. Chapman.
All right, good morning. We're here for an arraignment. Have you had a chance to review the charging document with your client?
We have, and we will waive the reading.
Okay, and how does he wish to plead to its charge?
He'll stand mute at this time, and we are not requesting a forensic.
All right, so I will enter a plea of not guilty on Mr. Chapman's behalf. What would be the estimated length of trial?
Probably 2 days.
I agree, Your Honor.
All right, appropriate for docket call on January 5th at 9:50 a.m.
Believe that's appropriate.
All right, anything further from the defense?
Your Honor, we would request that the court would consider at this time, Mr. Chapman has gotten all his other matters in different counties resolved, that the court would possibly consider a bond reduction at this time. He does have extensive family in the area. And like I said, the items that are here are his sole focus at this point.
Hey, Mr. McLennan, I guess right now, just to confirm, the bond is set at 50,000 cash or surety, is that right?
That is correct.
Okay, Mr. McLennan, people's position?
The people would oppose a reduction in bond, Your Honor. He's a habitual floor offender. He's facing a 15-year felony. People obviously believe there's strong evidence to support a conviction in this matter, so we would oppose a change in bond.
I mean, I don't know anything about the facts of this case, but just looking at the charge itself, I'm not sure that there's an immediate threat to public safety. The bond is set pretty high under those circumstances. I do think maybe that was influenced if he had other matters pending in other counties and those taken care of. He does have okay, well, the priors are just a couple possessions and a maintaining. So his priors are not terribly troubling, even though the possession of methamphetamine is technically a high severity felony. It's not, it's a possession charge. Is there any failure to appear concerns for Mr. Chapman presently or in the past? Okay, I'm going to amend bond to a $10,000 personal recognizance bond. with the
Thank you very
same
much, Your Honor.
conditions if there were any conditions.
Thank you, Your Honor.
All right, we'll see you January 5th at 9:50 in the morning, Mr. Chapman.
Thank you. Thank you, Your Honor.
Mr. Vogler, that brings us to People v. Mariah Tepe. Is she present?
I don't know. I've not seen her this morning.
Okay, well, we could pass the case. See if she appears while we're on our morning docket. But I think the jail is going to get Mr. Hoffman in the library. Is Mr. Stoneham here yet, or? Well, and that's an Attorney General case. All right, we might be a little bit ahead of ourselves here. Let's go off the record for a minute. Dash. Are you Mr. Hoffman?
Yes.
All right, up next we've got. I'm sorry. Go ahead. All right, up next we've got People v. Sean Hoffman, file 25-93368FH. Counsel, you want to state your appearances, please?
Jeremiah Buffalo, work on behalf of the people.
Mike Vogler representing Sean Hoffman.
Okay, and Mr. Hoffman's appearing from the Prescott County Jail Library by video. This is up for a docket call. We're currently scheduled for jury trial on Thursday, January 22. In terms of the docket call, Mr. Vogler, is that still our plan here?
Well, when I last spoke to Mr. Hoffman, which was Wednesday, I believe, he indicated to me, and maybe he's changed his mind, that he wanted to proceed by representing himself. I don't know if he's still of that mind or not.
Mr. Hoffman, Mr. Vogler indicates that you've expressed the desire to him that you might represent yourself. Is that true?
I've asked him to do several things for me.
You've asked him to do several things for you?
Yes, sir. And still haven't done them.
Oh, okay. Okay, so I hear that as not an unambiguous request for self-representation, but an expression of dissatisfaction with appointed counsel.
And withholding information.
All right, so under those circumstances, I would not consider that a valid waiver of the right to counsel. So Mr. Vogler will remain on the case. We're scheduled for your jury trial on January 22nd. Have witness and exhibit lists already been exchanged?
Yes.
Okay. All right, jury instructions and verdict forms 7 days prior. There'd be no need for further docket call then. Is that correct, Mr. Virgo?
Correct, Your Honor.
Correct, Mr. Vogler?
Yes, Your Honor. I would say this, that there could be, I would be meeting with the prosecutor. Some of their exhibits are video recording, body cams. There may be some, I guess, motion eliminates that I might want to file and have heard on January. That
the January 5th date?
Yeah, because unless, I mean, we may be able to reach agreement on redactions and things like that, or what should or should not come video.
You want me to just put it on for a docket call, just so we can touch base on it then?
That's fine, Your Honor.
Okay. We'll put it on the January 5th for docket call at 10:10 a.m. And Mr. Vogler, you have a motion for bond reduction noticed up. Go ahead.
Your Honor, the only thing I would add to this is that I mentioned a delay between a July 1st preliminary examination date, that was the date it was originally scheduled, and it was adjourned to July 15th. That adjournment occurred over the defendant's objection. My recollection is that the district court found good cause to adjourn it. That's the only thing I wanted to speak of as in terms of the delays that have occurred in this case. Otherwise, I believe the 180-day is set to come up here very shortly, December 5th, I think it was.
Okay. All right, Mr. Wirgo, people's position.
Relative to reductions in general, Your Honor, he likes to run and he's facing certain conviction. I think that if he gets out, he's going to stay out.
No, you don't know that. I have an address here in Rogers City.
Yeah, and Mr. Hoffman, Mr. Vogler did provide that to us with Ms. Musek. All right, well, in this case, it's a charge of fleeing and eluding third with the habitual fourth. The court did quash one of the felony counts on defense motion, and then there's a misdemeanor charge as well. I think that the bond was set pretty high. What's it set at? Oh, it's at 75,000 cash or surety. And now there's a motion to reduce it under the court rule that he's going to be served 6 months in jail. So the court needs to reconsider a personal bond. Under these circumstances, Mr. Hoffman's got habitual fourth notice in this case. And these allegations involve some dangerous driving. And we do have trial scheduled just next month. If I wasn't able to get trial scheduled for, say, another 4 months, I think I'd really give some thought to, where we're at on bond here. But I think given that we've got trial in January, I'll deny the motion to reduce bond at this time. All right, so Mr. Hoffman, we're going to touch base on January 5th with any possible motions that your attorney may have. And then we're scheduled for a trial on January 22nd. All right, we'll see you then.
Ms. Cheek has arrived.
Call People v. Mariah Cheek, file 25-93358. And Mr. Vogler, when we were last here, you said that you had subpoenaed some financial documents. Have you received those then?
I have received, there have been 3 subpoenas put out, not at the same time the last one was put out, but 2 of the bank subpoenas have come back. Not yet looked at the most recent one. The other one, which was to the owner of the alleged victim in this case, has not picked up service there. My suggestion to the court, my request really would be to set this matter for a spring trial date. My plan, I guess, will be to subpoena the gentleman to that trial with a request that he produce certain documents. I will come back, however, before trial and ask the court to give me a early return date on that document request. But at this point, any other way to do it?
Well, so help me understand, this is the complaining witness?
Well, it's the owner of the complaining witness. Yeah, it's a LLC that's the victim. He's the principal of that.
And you've sent a subpoena to that individual and they've not been served with the subpoena?
They have not read, it was registered mail, return received, has not been picked up. That went out before we were last here.
Mr. McLennan, what's your position with regard to the defense wants to get documentation from an owner of the complainant in this case? That seems like a very reasonable request and that your office should provide some assistance there.
Your Honor, I would agree that we'll provide any assistance we can, and it is a reasonable and required request.
Yeah. In fact, I'm going to direct that the prosecutor's office should assist with the service of the subpoena. Get a deputy to go serve him with that subpoena. Go get those records, have the police get those records for you. The defense needs those records. And Mr. Vogler, if that doesn't happen, we'll set it for a January 5 docket. I'll get you some trial dates today too. But if you don't have what you need, notice up a motion to compel or something. I mean, I think that's information that we could maybe. I don't know what the parameters legally are for the prosecutor's obligation to get those documents to you, but I'd be open-minded. And it sounds like Mr. Murgo agrees that this is reasonable, that what you're wanting is reasonable for you to obtain, and they'll provide some reasonable assistance with that. So if you can communicate with their office.
I will, Your Honor. They just said that I had always assumed that a subpoena from a defense attorney in a criminal case would have to be honored.
That would be, but first he's got to be served with it.
Yeah.
So you would need to get him personally served.
I would, but then I was at the seminar last month, and all these really good lawyers are saying, nope, you don't have to honor it, and the only way you can do it is get them subpoena to a trial date and get an early return on the subpoena, the production of those documents. So I don't know, but the bank responded, so I'm at least 2/3 of the way there right now.
Okay. What would be the estimated length of the trial then?
I thought we said 2 days.
Agreed, Your Honor.
Huh?
Agreed.
Okay. How about I could give you a Monday, Tuesday, March 16th and 17th. And I'll give each side 21 days to exchange witness and exhibit lists. And we'll come back for a docket call January 5th at 10:20. And Mr. Vogel, I guess I'll leave it in your capable hands to decide whether you want to file a motion to compel or whether you want to submit a trial subpoena and ask for an early return date, or whether the prosecutor's office is willing and able to assist you. And if you need any assistance from the court, you can notice up any motion in the docket call.
All right, thank you, Your Honor.
All right, anything further from the people?
No, Your Honor.
From the defense? Anything further from the defense? All right. All right, we'll see you January 5th at 10:20, Ms. Chief.
Thank you, Your Honor.
Is Mr. Bogner present? Yeah. You want to come on up to a table? I've got Mr. Hartman on Zoom. All right, up next, we've got People v. Michael Bogner. It's two file numbers 25-93375 and 93376 FH. Counsel, you want to state your appearances beginning with People?
Zachary McClellan on behalf of the people.
behalf of Michael Bogner.
Okay, we've got Mr. Hartman appearing by Zoom video. Mr. Bogner is present in the courtroom. We're up for a docket call. In these files, a couple possession cases. Mr. Hartman, what's our status here?
Your Honor, we're going to enter a plea. Does the court have the written plea agreement we've submitted?
Not. Do you have a copy, Mr. McClellan? Okay, I've got, Mr. McClellan's providing me a copy.
Mr. Hartman, may I check the accepted box on the plea?
Yes.
Okay. All right, I have a plea agreement for Mr. Bogner to plead guilty to, in file 93375, the possession of cocaine, and then count 3, the unlawful plate, count 4, unregistered vehicle, the remaining charges, and the file in 93376, and the habitual fourth would be dismissed. Mr. Bogner, you want to proceed with that, please, sir?
Yes.
Would you stand and raise your right hand for me, please? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can be seated. So, Mr. Bogner, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So listen carefully. If you have a question, go ahead and ask. I'm happy to answer it. If you need to talk to Mr. Hartman some more, you just let us know and we can make that happen. Do you understand that?
Yeah.
All right, now I have to advise you the maximum penalty that you can face. Count 1, possession of cocaine less than 25 grams is a felony. It's punishable by a maximum of 4 years in prison and or a $25,000 fine. Count 3, unlawful plate is a 90-day misdemeanor and or $100 fine, unless it was a commercial. Was this a commercial vehicle?
No.
No.
90 days and or $100 fine. Count 4, operating an unregistered vehicle is again a 90-day or $100 fine misdemeanor. Do you understand the maximum penalty, Mr. Bogner?
Yes.
Are you on probation or parole anywhere?
No.
Were you on bond for any other felony cases at the time of this incident?
No.
Do you understand if you enter a plea, you won't have a trial and you'll be giving up the rights that you would have had at trial?
Yes.
I want to remind you of the more important of those trial rights. You'd have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and you could question them. You'd have the right to present witnesses in your own defense and have me order them to show up. You'd have the right to testify in your own defense or to remain silent and not have your silence used against you in any way. Do you understand those rights?
Yes.
Do you have any questions for me or Mr. Hartman about any of those rights?
No.
Do you wish to give up those rights and enter this plea today?
Yes.
If I accept your plea, you give up any claim that it was caused by threats or by promises outside the terms of the plea agreement. Do you understand that?
Yes.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal to a higher court, then you'd have to seek permission to appeal. You would do so by filing an application, but the types of issues you could raise on appeal after you plead guilty are very limited, much more limited than if you were convicted at a trial. Do you understand that?
Yes.
Other than the plea agreement that do you understand the terms of that plea agreement as I set forth?
Yes.
Has anybody promised you anything else?
No.
Has anybody threatened you in any way to make you plead guilty?
No.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead to the charge of possession of cocaine?
Guilty.
How do you wish to plead to operate or displaying on a vehicle and an unlawful plate?
Guilty.
And how do you wish to plead to operating an unregistered vehicle?
Guilty.
So, Mr. Bogner, back on July 5th of this year, were you in Presque Isle County?
Yes.
Were you operating a gray Chevy Impala on a public highway?
Yes.
Was that vehicle properly registered?
No.
And did you have on it displayed a registration plate for a different vehicle?
Yes.
And was this your vehicle?
Yes.
So you knew that state of affairs that it had the wrong plate on it?
Yes.
Okay. And did you have some contact with law enforcement? Police
Yes.
pull you over or something? Okay.
Yeah.
And then were you found to be in possession of cocaine, controlled substance?
Yes.
Did you know that you were in possession of that substance?
Yes.
Do you have any lawful authority in the state of Michigan to possess that substance?
No.
Mr. Hartman, are you satisfied with the factual basis?
Yes, Your Honor.
McLennan?
Yes, Your Honor.
Mr. Hartman, are you aware of any other promises, threats, or inducements?
I am not.
And do you believe I've fully complied with the requirements of MCR 6.302?
Yes, sir.
Mr. McLennan, do you agree on both those questions?
I do, Your Honor.
All right, Mr. Bogner, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I hereby accept your plea. Mr. McLennan, any objection to continuation of bond?
No objection.
Bond will be continued, and we can schedule sentencing for January 5th at 10:30 in the morning.
Your Honor, I'm checking. Seems to be a popular day.
Since I only do one motion day a month over here, I'm going to ask you to do your best to make that date work.
I can do that, Your Honor.
Okay. All right, so Mr. Bogner, I'm going to ask you to see Agent Lesky briefly and maybe just get a card from her. You'll have to contact her to schedule an interview for her to write a report for me with some recommendations so I know more about you and your circumstances and we can make a good decision on January 5th, all right? You have to cooperate with that process. Good. Anything further, Mr. Hartman, from the defense?
Your Honor, what was the time on January 5th?
10:30 in the morning.
Your Honor, well, nothing further.
Okay, anything further from the people?
No, Your Honor.
Okay, you're all set. Have a good day, Mr. Hartman. Have a good day, Mr. Bogner.
Do you need the vice and right form signed?
Oh, you know what? I went over them with you. So if you want to hand that to the bailiff, we'll put it in the file.
I haven't signed these yet.
Oh, you don't have to sign them then. I went over them with you on the record. So you're all set.
Oh, okay, so I don't.
Okay.
There's 17 cases on the trial docket. Well, how many are being disposed of? Anything? Are you kidding me?
One.
1 out of 17? Is that right? Are we the only county or court in the land that that only has 1 out of 17. What's wrong? Okay, raise your hands. What's the problem here? Everybody's here in the room. I mean, 93% of cases are disposed of without a trial. What's one? How are we doing just 1 out of 17? Anybody have an idea? Right, you always have something to say.
I'm fighting to remain silent.
No, it's truly, I mean, we're all in this together. Or we're gonna be to the end of time trying cases. I mean, is that what we really want to do? I mean, is that in the best interest of everybody concerned? Okay, on Deontay Bird. Joe Vasquez.
Thanks, very good.
Mr. Vasquez?
Haven't seen him yet, Judge.
Okay. Are these cases, people,
Everyone's on bond.
where's Deontay Bird? No answer. I asked the bailiff to call into the hall for Deontay Bird. Everything's happening in here. This is, where's your attorney? Go find him, please. Thank you. Yeah, appreciate you. Derek Lewis.
Great. State's ready, Judge.
All right, that'll be first.
He's present on first run.
Rick Renfro.
He's present, Judge, and we are ready.
Roberto Santan.
Judge, he's present. This is the one that I inherited from Mr. Bruce Bob. I have spoken with Mr. Hand.
It's got your name on it.
It does have my name on it, Judge.
Does that need to get corrected?
No, she got it from Florida.
Oh, I thought we were here.
I have a formal appointment order from the court though.
Well, it's 1,000 days old. We'll need one if you don't.
I cannot be ready on it today, but next time I will be ready on it. Just some sort of resolution.
We have a trial docket next week.
No, Judge, if I could have 4 weeks, that would be.
It's 1,000 days old.
I understand,
Why are we
Judge.
switching lawyers?
Mr. Cobb represented this gentleman for a considerable period of time, and you just granted the motion to withdraw, and she just got this case, Judge.
I do have all of the video, the media, the
Did you talk
portal.
to him about all of that? Did you pay him some money?
No. It was news to me as of last week. She called me.
I
had no.
He didn't even tell you?
Nothing, sir.
No one informed him, and that is to
Okay.
no fault of his own, but I wasn't able to make contact with him.
But you retained it.
I did.
Okay. He needs,
Oh.
yeah. Yeah, Mr. Cobb needs to be in here with it. We need to have a hearing on this with him so that it's done the correct way on the record. Sometime this week. Okay. What we were saying, but we're gonna have something this week where I want Mr. Cobb in here to put some things on the record. Because that's just awkward.
Yeah,
It's for him, especially when there was.
It's been a strange.
Retained, that's just, that doesn't make sense. And we used to get cleared up for later problems. Cigar Patel, you're recent. Patel. You bet.
Judge, I'll grab his case right outside.
Y'all ready?
No, Judge, I'm.
It's 1,000 days old.
He's.
Are you ready though? But you're just.
Ready,
Okay,
especially
all
that-
right, that's all I want to know. Okay, Aaron Tyler. That's Bruce Smith. Aaron Tyler, are you good? Have you talked to your lawyer lately? Would you recognize him if you saw him? You would? Is he in the room here? I don't see him either. Can you call him and find out where he is, since it's kind of important to your freedom? You're charged with aggravated assault with a deadly weapon. What is this going to be, a 2nd-degree felony? 20 years in prison, sir. That's important to have a lawyer here. Gonzalo Alvarado.
Like he's coming in Houston. Here, most of them attend.
Came in from Austin, I got here.
I've talked to Mr. McLean, Judge.
This is Alvarado.
Yes, sir.
What about this?
He advised that he's still getting a ruling from the court on a pretrial matter, and
You know what that is?
it's an ex parte motion. I know that. I don't know the extent of it because it's an ex parte motion from the defense, right? But my understanding is that he needs a ruling on that, and had a prior hearing with the court and needed to do some follow-up, and that's why it was set on the stall. Subject to that, the state, of course, is ready. I talked with him last week. He had every intention to be here and resolve it. The pre-trial. Call the dance. Done. Good.
No, I would say the hour with the Thanks.
Well, once again, all cell phones off and out of sight. We're going to collect.
Okay, where's Mr. Alvarado again? Raise your hand. Do you know where your lawyer is in transit here? Because we have to have a hearing on this matter this morning. And he's not here. Okay, can you call him and find out? Tell him we're waiting on him. Thank you. That aside, we're gonna have a hearing on that, on those motions that were filed 2 years after, on the eve of trial, which doesn't get granted. That's not the template that's granted. Okay, Jonathan Ramos.
That's me, Judge.
Yeah, not you. You're Mr. Dirks. You can't fool me.
It's my case.
Oh,
Mr. Ramos is here.
All three of them, right?
Yes, Judge. And
We got all three.
Gives specially set next school on site school.
When are you not specially set so you can come here? Because we've had kind of a series of specially settings.
Well,
When could we be in early? Yeah.
Judge.
When was the last time we were tried?
4 weeks ago.
I don't know. How did we do?
I've had so many problems. I've never met all. Next doors.
We got it. We got it.
Yes. Actually, it sounds like you've got.
Sir?
We got other things we got to try.
Yes, sir.
That you have something specially set. But if we're gonna rotate it around, yeah. Kristen Dunn. Tristan Dunn.
They're out filling out the papers.
Daniel LeBlanc.
Which trainings? State trainings.
Drug court can take a case.
I'm good. Derek Lewis out here. In the law, actually, I'm not.
Exactly. No, I need to have Derek Lewis in here, but I think we have. Which one is it Bird? Bird's right, Daniel?
Bird's in here, yes, sir.
And that's the guy.
And Mr. LeBlanc, just
Yeah,
for the
we're not
course.
gonna play it in here. We're gonna go, you're gonna go across the
I'm not
street.
ready because this is the reason, because I have to reserve.
It's almost 2 years old.
If I have to reserve a lot of subpoenas on this, then the date.
Wait, it's 2 years old.
If I can get a date and actually do for sure.
No, you can't do that. No, you get a date every time you get a.
I have to reserve the subpoenas. I'm just- Then I have to.
Everybody's got the same problem.
Two things. One is I'm second chair, Mr. Boyd. I can still do that if I need to. But the second thing is this is the case that's got some complications with, it's Mr. Phelan that was threatened. And so I don't, well, I'm just talking about court charge and everything being over there.
The other thing.
I'm going to stand by.
I got to read.
The Corey Hillman.
Radio analysis or your announcements at work together.
Can we send something over to record?
Yes, sir.
Yeah, okay. Okay, which one? Well, Ms. Morris, you got different people here. The Bird is going to be number one here. So how about Christian Simeon over there? And that, good.
It's fine with this.
Great, thank you. Good. What are we doing with the rest of the?
Where are we doing it at, Judge? I heard you say.
Yes. And then Hillman and Neely and Rogers. Nothing, they're all trials.
Yeah, that's at this point, they're all trials where everybody's and everything. Multiple announcements, multiple trial dates and.
Second.
I would like to put his defendant's rejection of our offer on the record. Yes, that's what appropriate.
Yeah, we usually do that right from the trial.
Well, no.
Can we do it?
We're not going to do it. We're going to do it now.
No, that's not, I just say.
Because I don't want, because I'm going to send them over and then I don't want the last minute changing of the mind and then we don't have a trial to request it.
Oh, yeah, absolutely. We can.
Where's Christian Simeon? Come up.
If he does, it's going to do. You said figures the problem now.
Okay, you're Christian Simeon, 24 CR 777. You were here with Mr. West, your attorney. You were charged with aggravated robbery.
Okay.
I'm gonna try to get it next.
And that is standby.
Gunnar, I think we're gonna do this is gonna play down.
He said no.
Okay, just said, do you want to take deferred probation? Yes, sir.
When did you offer that? When did you offer that?
It's been on the table for a while.
What took, yeah, why do we wait until the time of trial when we're on the trial docket and then y'all decide you're going to do something that it was an important decision in your mind? Did you know about all of this? And nobody told me.
Judge, the initial offer was
Disposed of it.
prison. I reached out to him since I've been here and offered the deferred.
When?
That was just like last week, yes, sir.
Did you know about that?
No, sir. I just.
You didn't tell him about the
called, I
deferred?
couldn't reach him and I just saw him this morning.
Did you find out this morning?
Yes, I know now.
Okay.
Yeah.
Did they trial? I mean, y'all gotta communicate.
Yes, sir. Proceed, we'll do the paperwork. Yeah. Offer is made with mayor.
Like a television comedy. It's just, this isn't the way it's done. All right.
I'm gonna give us an out over. I'm available if you need.
It's somewhat, hey, Jimmy, Ham on, Hillman. Is that one we can send over to a court? What do you think?
I'm at your disposal, Judge.
All right, we'll send that one.
You want to,
Let's try that one over there.
the other option that I have with you, Your Honor, is we can go all the way back to the top of the docket with Derek Lewis.
Say that again?
The other case that I have with you that we can consider is at the top of the docket.
Derek
Lewis.
Where is he?
It's much older and it's with Rife and he's on bond. And in reality, he's a habitual offender and probably if we're going to send something, it should be that one. But I can go on both, you can send them both over there, you know?
Give me backup car.
Yep. Okay, Orlean Neely. That's yours, John?
Yes, sir.
And Boyd.
It's Mr. Boyd's case, but we're ready.
That's okay. What are you saying?
I'm ready. Yeah, we're ready on this. This was. Four, six, yeah. That's
David Rogers,
I'll be outside with you.
same two.
Yeah, I'm just.
Same two of these.
Yes. Same thing. We've been set up for, we're not still ready.
Kirsten Bailey. Langston. Okay, Carson Moore. Grace Jackson. Onwin. Yeah.
Yes.
Jackson.
Yes, Your Honor.
Question mark.
We will be ready next setting. This is the first sitting of the trial.
Yeah.
I have a difficulty and get the subpoena.
It's gonna be resent.
Appreciate you.
Yeah. You bet. So one, so Deontay Bird here. Get Kimler here, because I'm gonna send Derek Lewis to drug impact as one. And then number two is Christian Simenon.
That's gonna be a plea yard.
That's gonna be a plea.
Yeah, plea now.
But it's Corey Hillman.
Yes.
We can send that over to.
That, yes, that, all right, afraid to go.
Those two will go over with drug impact.
Yes.
And then one is Bird here. And then. Let's play like that doesn't go. What's our second one? Then how about Neely and Rogers in that order, John, if you don't go to trial in that order.
Mr. Boyd will be here to.
Yeah.
Back on that.
Well, that's pretty certain on that one. Right, sir?
Yes, sir.
Okay.
Do you want us still as backup or just go ahead and go over to the court?
Go to a court.
Okay, I'll let my other clients go then.
Hey, if they're,
There'll be Tuesday.
Yeah.
Here's all of these, I'll give these to you. We got three of these. And
I think Moore is ready for a plea.
nice, Alpin. Yeah, look, you can likes them. I think he's right out there. There are a whole bunch of stuff here. Hey, on Alpin. Oh, okay, we're in that docket now, but we got you on some other stuff too. You need to talk to me about that, but on the trial docket. But what are we doing on Alpin?
His offer was 30 years.
I know, what we can do.
He's saying no to that. That's a trial.
Okay, we'll lead him out.
Yes.
Alpin.
Yes, sir.
Thank you. What about Jacoby Broussard?
That's a sentence.
Thank you. Ready on it?
Yes, I can get him. I just gonna be talking with him. You want to get Al or Broussard first? And then I also have Molo.
Alpin, that's you? Al, is Alpin? Yes. Correct. Is that right? Yes, sophomores. Is Mr. Adams your attorney?
Yes, Your Honor.
You were charged in two cases, 25 CL 873 and 874 with the first three felony of aggravated sexual assault with a child and indecency with a child by exposure. First degree felony and aggravated sexual assault, you were looking at up to life imprisonment if convicted, and then the indecency up to an additional 10 years in prison in that case. What are we doing on these two?
Judge offer was 30 years in prison. He's saying no, that's a trial.
Okay, that's right.
I want to try to fight from Anderson.
Or is that right? You want to try it? You're not accepting the deal, so it's going for trial, right? That's what. Yes. There's only have two choices. You're either going to accept the offer or it goes to trial. Which one is it, sir?
You say that you're going to fight for
which one?
That's what
You have to speak out in English for the record. What is it you want? You've got two options here. He's talked to you. I know about it.
Necessary. I'm trying to. Question is, you said you're on fight for innocence. Do you want a trial or not? I don't want a trial. How you gonna do that?
There's only two choices. Pay attention closely. It's either the option of an offer that's been made to accept it or go to trial. Those are the only two. Huh? Way over here.
You're not taking it from.
Okay. It's set for trial. This will be we'll set first the aggravated sexual assault, the first degree. Over here is we're over here. We're going to set this for trial. When can you be ready? This is going to fast track. We're going to get this thing done as soon as possible.
Whenever you ready for it, Judge, I can get it.
Mr. Ant, can you be ready in a few weeks?
Whenever you said it,
All right. It'll be ready next month. We'll try it next week. Thank you. That is all.
Thank you, Your Honor.
Next is, I've got Gregory Woods.
Who?
Gregory Woods, I saw him. Jacoby Diamond Broussard. Langston, Jacoby Broussard.
Yes, sir.
Citizen.
That's citizen.
Jacoby Broussard, thank you. No problem. Is it right one much? We now call 22-39417, the state of Texas versus Jacoby Damon Broussard. You, Mr. Broussard?
Yes, sir.
Present with your attorney, Mr. Adams, and the state's attorney.
Yes, sir.
Earlier, you entered a plea of guilty to the first-degree felony of murder in this case. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? State?
I reviewed it. I have no objections or changes, Judge.
And defense? Then without objection, it's made a part of the record for all purposes here. The agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we really are looking at no less than 5, no more than 30 years confinement in prison. I believe there aren't any other options, correct?
Correct.
Is that the way you understand it, Langston?
Yes, sir.
All right. State, want to go first and last?
I'd like to go last, Judge.
You can go first and last. You can defer. Mr. Adams, go ahead on behalf of Mr. Broussard.
Judge, if you look at page 1 of the pre-sentence investigative report, and I'm looking right above defendant's version, you'll see that it was 3 people that was all charged with murder: Jacoby Broussard, Arthur Small, Charles Moss, and they all were charged with murder. Prior to today, it's my understanding that Arthur Small and Charles Moss has already pled before your court, Judge. And Mr. Helm can correct me if I'm wrong, but I understand that Mr. Small got 8 years, and at that time, Mr. Small was already on probation in your court for another case. And then I believe Mr. Moss, and Mr. Ham can correct me if I'm wrong, I understand he ended up pleading for, I believe, 15 years, 20 years, 15 years, I believe. So what I'm asking, Judge, is if you look, and I'm only looking at page 1. When you look on page 1, Judge, you see specifically where Mr. Thomas was shot at the canal. And then he apparently had got into a fist fight. And I'm reading specifically where it says when he witnessed the fight between Thomas and Trey Moss. Trey Moss was the one who was already in your court, and I believe he took a 15-year deal. He is the one that got into the physical fight with the deceased in this case. And then apparently the deceased came back and there was gunshots. Judge, the thing that we would add to the PSI, and Mr. Ham has already provided this to my office, was the forensic post-mortem examination. And I do not believe Mr. Ham is going to contest that according to Judge, what I was going to tell you is according to the forensic exam, the deceased had a gunshot wound through the right thigh. So he took a bullet to the right thigh. And also it says it was another bullet to the left side of his abdomen. And that's in this report, Judge. But here you go, Judge. I'll just show that he was shot twice. One to the thigh and then one to his abdomen. Okay. So our position. Copy this. Yeah. Yeah. So our position, I can make a copy. You have got it. Oh, so what I'm saying, Judge, is that there were 2 shooters And we believe to make in line with what my client said, where he said in the defendant's version of what happened.
How many times was the complainant, the victim shot?
Well, we know he was shot twice because he
At least.
because one was to the thigh, and that's what I'm looking at right there, and the other one was to the abdomen. So we believe that there was two shooters, and with the two shooters, and that's revealed in those two wounds. And I was letting you see where I got that from. It's our position that the wound to the abdomen came from Mr. Moss, and then apparently the wound to the thigh would have been my client, Mr. Broussard. And Judge, if you look specifically, and I'm ready.
Why do you say that?
Because
well, how can you determine that not being present?
No.
And not having any other scientific evidence to support that other than
because he was there.
Okay, it's what he's telling you.
Right, because he was there, because he saw everything. He would have been there. And Judge, what I'm saying,
what is it you're saying his responsibility was? What did he do?
What I'm saying, with there being with the victim being shot twice, I think, hey, he's a party to the offense. But what I was asking, Judge, is that when you look specifically to his criminal history, unlike Arthur Small was on probation when this happened, and he agreed to be a witness for the state to testify against my client. And then unlike Mr. Moss, who's the one that's actually having a physical confrontation with the city, it wasn't my client. And I'm asking if you just read from the PSI, the guy who's the instigator of all of this is Mr. Moss. He's the one that's beating up the man and having a physical fight with him. And he's the one that has more incentive to shoot him than anybody because he got to fight. And our position is that you had two shooters, and that and having two shooters, my client is culpable for firing a shot, but the one who is the most culpable is Mr. Moss. And again, like I said, Mr. Ham can correct me, but I thought, if I'm not mistaken, he received 15 years. I could be wrong, it might be 20, but I know it was not 30 years. And what I'm asking the court is, Judge, is that if the man who we believe is the most culpable got 15, or I know it was no more than 20, then I don't believe my client should get the max out 30 years. And the reason I'm concerned about that is that, Judge, if you look on page 2, I see where the mother went in there says that she wanted him to get 40 to 50 years in prison, and the dad felt that he should get more than 30. But in my opinion, Judge, in arguing on behalf of my client, the person that was most culpable was Mr. Moss. And Mr. Moss did not get a 30-year sentence. And since he didn't get a 30-year sentence, it's not going to be fair for my client to get hit with 30 years when the man who was most culpable was not. And that's why I showed you, Judge, that it was at least two. There's no doubt, according to the autopsy report, it's no doubt he was hit twice. There's absolutely no doubt about that. One to the thigh and one to the abdomen. And I think that my guy is responsible for the thigh, but he's not responsible for the one that went to the abdomen.
No, you've seen the pre-sentence report.
Yes.
He's not responsible for anything.
No, I didn't say that.
That's what he says here.
Okay.
But he didn't shoot anybody.
No, I hate.
But you're saying he did shoot somebody.
I think that he needs to clarify that. Yeah, he needs to clarify that.
Oh, he does?
Right.
Well, he was pretty clear here in that when he pleaded guilty, which was odd, but then he later admits he didn't shoot anybody. That's his inference here. But you're saying he did, even though you weren't there.
I wasn't that, Judge, but the thing is, like I said, and the reason why I brought that to your attention, just looking at the autopsy report, to suggest that there was two wounds, and there's no doubt about that.
I'm not surprised. I'm looking at what all this says. It appears as though two people did shoot. That's why two people apparently pleaded guilty.
Right, and it's actually three people showing.
But the pre-sentence report, he's trying to play both sides. I'm guilty, but I'm really not guilty. He can't figure out which one he is, Dr. Jekyll and Mr. Hyde.
And that's kind of a problem. That's why I was trying to reconcile his statements with the objective.
How do you reconcile he didn't shoot anybody who was pleading guilty and he wants to accept responsibility? How does that work? How does it work?
No, I think that he's going to accept it. responsible to fire.
But that's not what he says here. When he had a chance, he pleaded guilty under oath, but when he went to talk to the probation office and changed the direction of the latest one. I mean, being truthful and forthcoming is important. Do you know what happened here? A human being died. A human being, one of God's creatures. You had responsibility with that as well as the other person. Look, you killed somebody. You feel anything bad about that?
Yes, sir, I do.
Oh, do you? You certainly weren't forthright here at the probation office. You want to just interrupt me?
No, sir.
That's the way you are, isn't it?
No, sir.
I get the feeling you like to control the situation, like you controlled this shooter. You seem to be the boss.
No, sir.
No, that's the way it looks.
No, sir, you're the boss, sir.
Well, no, that's the way, and that's not the way this pre-sentence report appears. You want to play both sides. I want to make a deal, but I didn't do it. Can't have it both ways.
No, sir.
I'm gonna let you talk for just a second. I want what Dave had to say.
Ready, Judge?
Yeah, go ahead.
Let's, let me address some of the statements by defense counsel so that we can get on the right page. Mr. Small pled to a lesser included offense of manslaughter and received 8 years TDC. That was all part and parcel of an agreement for him to testify against Mr. Broussard. He stated at the time of this incident and reaffirmed during.
You feel, by the way, you feel like that is fair and appropriate under the circumstances?
Yes, sir.
Go ahead.
He's stated early on and then reaffirmed during trial preparation that Jacoby Broussard is the only person that shot Christopher Thomas on that date. There was a fourth person that was there. All this is a part of discovery. That individual's name is Ladarius, and he's Ladarius Lofton, and he's been cooperating since the incident occurred. He was one of the 4 individuals in the car, and thanks to him, he came forward whenever this body was found and told the Port Arthur Police Department about the fact that this young man was actually killed. Up until that time, they had not seen the bullet wounds in the body. The body was found in the ditch, but they mistakenly believed that it was some kind of an overdose. Had Mr. Lofton not stepped forward, we never would have gotten to the point where a murder investigation would have proceeded. He was not charged. He was present at the time, and he says again that it was Jacoby Broussard that was the shooter in this incident. So that's an uncharged individual out of this incident, and the reasons why. Arthur Small was not on probation, as defense counsel said. His agreement is based upon his cooperation. The other defendant, Charles Moss, only entered a plea after Mr. Broussard accepted responsibility. He did that on November 13th. He is waiting sentencing. His agreement was a lesser included offense of a manslaughter. Now, this all goes back to, and the whole reason why we're here talking about a cap of 30 for this individual is that factually, Mr. Adams did get one thing right. There were 2 wounds. There's nothing I can prove that there were 2 shooters. There was, we have firearms reports, and experts were ready to come forward to show that the 2 wounds that occurred on this came from one gun, not from separate guns. So we know that fits with what the other 2 witnesses were prepared to testify. That puts a responsibility on this man for killing Christopher Thomas on that day. There's no doubt that the facts are that Mr. Moss was involved in the situation. There was a fight between Mr. Moss and Mr. Thomas prior to the incident, but there's no evidence other than this man's suggestion that Charles Moss was a shooter. And I agree with Your Honor, as you always do, you honed in on the fact that he wasn't accepting responsibility. He really hasn't done it today. His lawyer has. He stated emphatically in the PSI report that he was there, but he didn't do it, that it was Charles Moss, shifting the blame over to him. The only thing that's good about that is that him making those kind of statements led to Moss accepting responsibility afterwards. But it doesn't step away from the fact of he killed a man. He killed a man that day. He left him there in a ditch, half closed, shot in two different spots, and he's the one that's responsible for it. His parents are hurting. You can read that. Their wounds and their emotions just come out on the pages where you read what their responses are to this. I've dealt with this family from the very beginning of this incident when it first got indicted, and we learned that unfortunately Mr. Adams represented the decedent before this offense occurred. This family has never been satisfied with how the system has worked in this regard. They did approve the agreement that I made, but it was very reluctant, as you can tell by their statements here. I have no doubt as I stand before the court that the man responsible for the death of Christopher Thomas is right before you. He pulled the trigger. It resulted in the two wounds. The two wounds is what caused that death. The concession to bring it down to 30, as opposed to the cold-hearted killing that it was, has a lot to do with all those facts I was just going through. There was a lot that was going to get muddy at the time of trial. There was going to be blaming on other individuals instead of accepting responsibility. I thought I had it worked out to where that was going to occur, and then we get his statements here. That being said, nothing has changed. The facts of the case, which are that Mr. Thomas was shot 2 times with the same weapon. In order for it to occur, as defense suggests, there would have had to have been some exchange between Mr. Broussard and Mr. Moss so that one shoots and then the other turns around and shoots. Is that possible? Yeah, it's possible. But it doesn't change the fact that this is the individual that 2 witnesses says killed that man and left him for dead in the ditch. 30 years is what's appropriate.
Judge, one part that Mr. Hamlin is leaving obvious is that witness, Mr. Small, has made multiple statements. When he first was approached and gave an interview, he said one thing. Then later on in the case, when the DA's office investigated him, he says another thing. My only point is that Judge Moss, as Mr. Ham stated, has entered into a plea agreement. He's saying it's coming back for sentencing. It wasn't a 30-year cap on Mr. Moss. And what I'm saying, Judge, is by way of extrapolation and by way of deduction, when you read the first page of the PSI, it was Moss who had a physical fight with this deceased guy. It was Moss that was the one that was throwing blows with him, punching him. That was Moss. And the deceased came back. So if out of everybody there, the guy, in my opinion, that would have been the most heated, the most angry, is going to be the one who had the physical fight. And what I was trying to say, Judge, and that's why I kept pointing out about the 2 wounds, one to the leg and one to the stomach. You had 2 shooters, and that Mr. Moss is going to leave out of here with what, 15 years or something on the cap that he made for Mr. Moss. What I'm saying is that my client should not get 30 when, if you look at his criminal history, to my understanding, Judge, when you look on the last page, he doesn't have that criminal history at all. At all. He does not. And he did go to Memorial High School. He has had employment. And I think, like you said, Judge, it's best for me to, let him do more talking than me. But all I was trying to get the court to see is that there were 2 shooters based upon the wounds, one to the thigh and one to the stomach. Now, I guess the question for you today is do you accept responsibility for the wound to the leg?
Yes, sir. Take responsibility.
Yeah, they know.
And with that, he's taking, so what I want to do, Judge, is to correct and amend the PSI, because what he is saying is what I said.
Does that kill the man, the wound of the leg?
Well, I think that when you if two people.
Does that kill the man?
I
take it from your silence, you don't have any answer to that. Yeah, well, the pre-sentence report, are there any objections to the pre-sentence report?
No, I'm not going to object.
Then it's made a part of the record for all purposes. According to the authorities that investigated this case, they disagree with you.
Yes, sir.
It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. After he shot Thomas, they left the scene. And then the next morning is when the deceased's body was found in the canal, left to die.
Yes, sir.
And really, both folks who did the shooting here, the defendant and the other co-defendant, have much culpability since they acted together. The just heinous nature of his leaving this person just to die and walking off as though they had a big meal and were going somewhere to watch a ball game or something. It just flippant. To treat a human being like that is disturbing, and to change stories through this pre-sentence report, you are not guilty, and then, yeah, but you are guilty, trying to figure a way to manipulate through this without being held responsible. But the investigators who were close to this case and investigated it believed otherwise. Both of you have pleaded guilty. Both of you are responsible for the death of this human being. And the family members are upset that even this limit of 30 years imprisonment just does not seem fair to them. The mother states he should get at least 40 to 50 years in prison. None of them called 911. None of them rendered aid to my son. And he was left there to die. And then to be found later the next day. The father of the deceased, he shot my son, made a choice to do that. He should get more than 30 years. But that is not the maximum. And he is disappointed that, as both of them, that you're not being held for more responsibility to taking their son's life, which was a tragic thing here. Anything else to add, by anything?
No, I was just asking, just since the other guy who was the fighter did a cap deal that was less than the 30 years, and as to my understanding, that cap was around 15. In comparability, Judge, what I'm saying is that I would ask for my client to be somewhere around that 15 to 20 years.
Do through investigation, again, the authorities think otherwise about the responsibility of your client. It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. That's what they think from their investigation. You weren't there, I wasn't there, but the investigators put this together. He pleaded guilty. The other guy pleaded guilty. There's both responsible. Anything else?
That's your judge side.
Mr. Bruce, anything else you want to add?
I apologize. I'll take full responsibility.
How do you take the life back?
Sure, I wish I can.
Yeah, well, do you think an apology makes a difference to that family?
I sure and I apologize to the family. It didn't happen. It shouldn't happen.
I guess they're going to there's not much they can do about it, but they want their child back. Can you do that?
Sure.
You shouldn't have taken it away from another human being. It's not, it was our creator who created it, like created you. You have no right to take it away. You understand?
Yes, sir.
You have to pay a price. You pleaded guilty in this case voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years. The judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offense that will be rendered on the judgment. You will be given credit for all time you have served and a direct relationship to this case. This is the sentence. This is what's fair and just. Unfortunately, I just wish there was something in the law we could figure out how we could bring life back. But it is forever when it's taken away, and you were responsible. That is all. Ashley Muller.
She's here, Judge. That's a LTRP. Muller.
You have that. Yeah, two of them, right? Two motions.
Right.
What are we gonna do?
Judge, here's what I'll have to do. If you wouldn't mind, I don't want a full-blown hearing on anything like that. The thing is the offer is 1 year for the state jail and 3 years for the TDC jail offense. She's not accepting the offer. However, the main thing is, I think the fate is all we really need to know. Well, what I wanted to do, Judge, is I just wanted to get some people. She had, to my attention, just kicked them. And that was one of the reasons why. And I just wanted to get some witnesses as well as her medical records to show you that I don't know if probation is aware, but she's had a mass. Did you know about the mass on her? Okay, well, yeah. So if you can so I anticipate.
Come on up.
So far good.
All right, you were Ashley Washington Molo.
Yes.
You were on probation in these two cases. There's one where you were placed on probation for a state jail felony of theft. You pleaded guilty to, let's say, unlawfully appropriating property closed on a sex toy. Okay, well, that still counts as an item. But you have two or more prior convictions of thefts, which means that anytime you steal a pack of gum, it's automatically a felony. Do you understand? I'm looking at 1, 2, 3, 4, 5 convictions of thefts. And then in 1385, you were placed on probation for 10 years for continuous family violence, a third-degree felony in that case. And there are allegations, as the other motion, that you have failed to perform your probation responsibly by, looks like, not reporting. It looks like you absconded. You quit reporting in May of 2024 and then just kind of walked off the job.
Yes, sir.
And then they had to go find you. And that's 99% of probation is reporting. You didn't do that. So you're looking at up to 2 years in prison in the state jail, and this theft case and up to 10 years imprisonment on this continuous family violence case. What are we going to do just today?
So what today, that's the reason why I was asking you for like 2 weeks and not, I don't necessarily need to contest it.
Is that all you want, 2 weeks?
Yeah, because
Okay,
she's gonna have some.
It'll be reset for 2 weeks.
That'd be
Okay. All right, that is all. Thank you. And I've got. Did you have a plea in the trial docket at all? Did you have anything else? Maybe not, think that's gonna be too. Yes, please do the papers. I don't know now. All right, off the trial docket, what else do we have on dispositions?
Gentlemen signed up, Jeff.
All right, come on out. Okay, the finish name.
Kristen Dunham.
Or both on this.
Marching, or the end.
One you holding his legs, the other one holding his arms.
Hearing Mr. Roebuck's papers.
Your right number,
Well, it sounds like a
place it flat right there, don't roll it.
creative way to handle it. So.
There one more time.
You have to be stronger.
Place it flat right here.
I'm reading. They beat up on me really bad.
Go stand in front of judge.
Okay, do I have that file?
Sorry.
Just one thing.
2 cases. And there's.
Is he pleading to 2 or 1?
It's pleading to 2, and it's going to be a split sentence. It's going to be pen time on one, probation on the other.
Wasn't gonna be easy today, was it?
No, sir. I was just following your example from years back.
My example. From
Yeah.
years.
You used to split sentences all the time. Oh, well. I'll go get on the phone too.
2 cases are called 23 CR 1745 and 1746. The state of Texas versus Tristan Kelly Dunham. Is that you, Mr. Dunham?
Yes, sir.
Present with, is Mr. Roebuck going to be the lead with Mr. Roebuck as your attorney in this hearing? Does the defendant waive a formal reading of the indictment and the arraignment in each case here? Can we proceed with summary? In summary, in 1745, this alleges that, well, they both, let's take them together. 23 CR 1745 and 1746 are individual indictments alleging second-degree felonies of manslaughter.
Intervention in lieu of conviction. We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to these charges, but instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. This does not apply to the traffic case, but it applies to all the drug cases. And what we're going to do is adopt a treatment plan, which at this point includes inpatient treatment in a community-based corrections facility. You're going to follow the rules and you're going to refrain from the use of drugs or alcohol during the treatment period. If you do all of those things, that part of the case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, then I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand all of that?
Yes, sir.
How old are you?
62,
How far did you go in school?
11th grade.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Just methadone.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No.
Are you a United States citizen?
Please?
Are you a United States citizen?
Yes, sir.
Other than what I've told you today, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have 2 sets of documents. They are each entitled change of plea and entry. They each have a signature above the line defendant. Is that your signature?
Yeah.
Did you review these with Mr. Deary before you signed them?
Yes.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of possession of a fentanyl-related compound. This is a 5th-degree felony punishable by up to 12 months in prison and a $2,500 fine. We're also going to enter a plea of guilty to possession of drugs, failure to stop after an accident. Those are each first-degree misdemeanors punishable by up to 180 days in jail. And we have a paraphernalia charge, which is a fourth-degree misdemeanor. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC and the drug cases and the sentence in the traffic case. Is that what you want to do?
Yes, sir.
Mr. Harris?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about February 18th of 2025, Turtle Creek Township, Warren County, Ohio, the defendant, Todd Gwinner, lost control of his vehicle, striking and damaging the vehicle of another motorist, and left the scene without making contact. In the vehicle was found a mixture of controlled substances and other drug-related items, including fentanyl, and also digital scale, cut straws, and chore boy. The vehicle was located abandoned. The victim's vehicle suffered disabling damage. There were 2 witnesses on the scene that described the vehicle. The vehicle was found in a nearby gas station abandoned with significant damage. Found in the vehicle was the white powdery substance, digital scales, cut straws with residue. The defendant, Mr. Gwinner, did call the next day to report the accident, but avoided contact with police until mid-April. Defendant did admit driving the pickup truck, blamed the accident on mechanical failure, admitted the powder was fentanyl but couldn't be certain. He did admit to having a drug addiction.
Anything on those facts, Mr. Deary?
No, Your Honor.
Mr. Gwinner, did you hear those facts?
Yes.
Do you admit they are true?
Yes.
Do you understand the right you're giving up by entering a plea?
Yes, sir.
Which plea?
Guilty.
With regard to the drug cases, I'm going to accept your plea of guilty, and I'm going to order that that part of the proceedings be stayed. Excuse me. I think you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you may have been rejected here in open court. You're going to be under the general supervision of the probation department. You're not on probation for that part of the case. But those are the folks that supervise my ILCs. It's going to be part of the treatment plan that you enter into and successfully complete a community-based corrections facility. I don't have strong feelings on which one you do. You and your officer can get together on that. Right now, you are not eligible for a CBCF. You got some work to do before you can get there. But as soon as we get you eligible and accepted, we'll get you over to the CBCF. With regard to the traffic charge, any reason not to go forward with sentence on that?
No, Your Honor.
Anything additional from the state?
Your Honor, I did speak with the victim in this matter. She did indicate insurance took care of the damage. There is mandatory suspension associated with the offense.
All right. Anything, Mr. Deary?
No, Your Honor.
Anything you want to tell me, Mr. Gwinner?
Yes, sir.
All right. The court is going to place you on probation in that case, 3 years of community control. The rules are going to be the same in both of these cases. And I am going to suspend your license for a period of 180 days. Is there anything else that we want to do?
No, Your
No,
Honor.
Your Honor, thank you.
All right. No fine. We'll just impose the costs.
Thank you, Your Honor.
All right. Good luck to you, Mr. Gwinner.
Thank you.
Of Ohio versus Andrew Stutz. This is case number 25 CR 43089. Present before the court is Mr. Stutz, represented by Mr. Swift, and we have Mr. Harris in the prosecutor's office. We're here today for a pretrial, but it's my understanding Mr. Stutz is going to enter a plea of guilty to one count of violating a protection order. Is that accurately stated?
That's correct, Your Honor, and he would like to read the court a statement regarding bond.
Okay.
Do you want it now or after we play?
That's fine.
I'm asking you to please put me on probation and let me back out to my family. I've been locked up on these charges since 10/10/25. I'm not on any parole or probation. I do have a job and a support system. I have not picked up any felonies and only 2 non-driving misdemeanors since 2021. I've been off of parole since August 24. I know my record is not the best, but I'm working on changing. I will comply with probation, drug testing. I will do alcohol and drug assessment, anger management treatment, and mental health treatment. My family needs me out there, and I need to be with them. The time I come in front of you, I have 57 days jail time credit. If I mess up probation, I'm willing to do my time in prison. I ask that you waive the PSI and just continue the sentencing today. My job is on the line, and so is my house. I will not have any contact with the victim, Lindsay Frank. The protection order and the protection order and the no contact order can both stay in place. Please let me out on bond, OR bond. I have to be back at court for Lebanon Municipal Court for driving under suspension on the 13th for a $100 fine. That's going to show you that I'm trying to work on things. I'll have my fine paid off by the time we come back to court. That's all I have, sir.
All right, so what's being proposed here today, Mr. Stutz, is that you are going to enter a plea of guilty to one count of violating a protection order. And we're going to set this for sentencing in January. How old are you?
32 years old, sir.
How far did you go in school?
8th grade.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
Yes, I am. Not that it's mind altering or anything. I'm just seizure medications and bipolar medications.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions with the attorneys about the case. If you enter a plea of guilty to this charge, I'm not going to sentence you today. I am going to do a pre-sentence investigation because I think that we need a PSI if I'm going to properly sentence you in the case. So we're not going forward with sentence today. And my inclination, Mr. Stutz, is to have you serve some local jail time and then release you into the community, put you on probation, and if you don't abide by the terms of the no contact order and the protection order, send you to prison. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Swift before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of violating a protection order. It's a 5th-degree felony punishable by up to 12 months in prison and a $2,500 fine. There is no mandatory prison in the case, but I've already told you sort of where we're headed. If you violate and I do have to send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, Mr. Stutz, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. They have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, to compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts? And also, have we had the opportunity to confer with the victim?
Your Honor, I have received a victim impact statement today via email. So that's the only contact. I haven't had personal contact with her, but there was an email that was sent into our office.
All right, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment as to count 1, that on or about September 17th of 2025, while an inmate at Montgomery County Jail, the defendant Andrew Stutz violated a protection order by attempting to contact Lindsay Frank, who is located in the city of Lebanon, Warren County, Ohio. Defendant has previously been convicted of violating a protection order, and there was a protection order in place, which was granted on August 7th of 2025, effective through July 25th of 2030.
Anything on the facts, Mr. Swift?
Nothing.
Mr. Stutz, did you hear those facts?
Yes, sir.
Do you admit they are true?
I believe yes, sir.
Do you understand the rights you're giving up, entering your plea?
Yes, sir.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. I'm going to order a level 2 pre-sentence investigation. We're going to come back here in the middle of January for sentencing. I am not going to release you today, Mr. Stutz. I want to see a pre-sentence investigation before we do anything.
Will the court consider work release privileges for?
I will not consider any kind of modification of his bail whatsoever. Not until we get back for sentencing. All right, we'll see you in January, Mr. Stutz.
Thank you.
Thank you, Your Honor.
All right, we are good for the morning.
In 1745 involving vehicular manslaughter, and in 23 CR 1746, a second degree felony of accident involving death. Oh, one fatality?
Yes, sir.
2 cases out of this one event, right? Correct. All right. Both of these, sir, indictments allege that this occurred on or about August 12th, 2023 in Jefferson County, Texas. And in 1745, the manslaughter, it is alleged that you recklessly caused the death of Christian Michael Sykes by operating a motor vehicle on a public road in excess of 100 miles per hour and failing to maintain control of the vehicle, which struck the rear of another motor vehicle occupied by the victim in this case, causing that vehicle to flip and leave the roadway, which resulted in the victim being ejected from that motor vehicle. Do you understand what you're charged with in the second degree felony of manslaughter in 1745?
Yes, sir.
And in 1746, this alleges that that you intentionally or knowingly drove a vehicle that became involved in an accident resulting in the death of the victim. And knowing that that accident occurred, you intentionally or knowingly left the scene of that accident without giving your name, address, registration number, etc., and without rendering reasonable assistance to the victim when it was apparent that he was in need of medical treatment, and that is in violation of the other offense called accident involving death. Each of these are second degree felonies, which mean if convicted, you face no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range that was applicable in these cases?
Yes, sir.
Agreements have been reached where you would be pleading guilty. Is it the same agreement in each case?
No, Your Honor.
In 1745, an agreement has been reached. You would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there will be terms and conditions of probation, which
Judge, there's an agreement under the new law, you can order child support. They're agreeing to waive the
ex post facto part of it, waive the right to not rely on that law, but we've agreed that he's going to pay child support to the child reaches 18. That's going to be determined by the time we do sentencing. We're asking for a pre-sentence report because we're going to use the family code to determine it.
Was he the sole provider of, the deceased was the sole provider of the child?
No, sir, that's why he's got, there's a mother and we just got.
Deceased leave a mother to the child?
Yes.
A wife?
Yes.
Okay. Is she here by any chance? You are that, is she a man?
They're present and this has been all discussed with the family before we made this decision.
This is agreeable with y'all? Okay.
The agreement we discussed prior to
on this, in this case, he was going to be pleading guilty. He would not be found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. He would be fined $500. There would be terms and conditions of probation that this court can assess. And one of these is that the agreement that he is going to be ordered to pay child support in an amount to be determined by the court after the pre-sentence report is prepared. We're going to enter the plea, come back later and make sure that all the I's are dotted and T's are crossed and that everyone understands and is on board with the plan. Because this is changeable if necessary. And JCDI, okay, you have a substance abuse issue? No? Okay.
That was a request of the family.
Okay, well.
Yes, sir. I want to make sure.
So is this your understanding of the agreement on this case, 1745?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this case, charging you with the second-degree felony of manslaughter, guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
We're going to go to 1746. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary? I think we discussed it, that you are alleged to have committed the second-degree felony of accident involving death. And in this case, you were facing a similar punishment range as the other, although third-degree felony is checked here.
Should be second because of death. Should be second degree.
Okay, everybody right on that?
Yes, sir.
Because that's the way it's indicted.
Yes, sir.
The grand jury indicted it as second-degree felony.
Yes, sir. It is second.
Okay, you're facing a second-degree felony here, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand that, sir?
Yes, sir.
An agreement has been reached. You would be pleading guilty in this case and sentenced to 3 years in prison. That would not be suspended. That would be flat prison time.
Yes,
is that your understanding of the agreement, which would run concurrently with the preceding case?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of a second-degree felony of accident involving death, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
I'm going to show you in each case what has been marked as State's Exhibit 1. Did you sign those documents? Understand them, discuss them with your attorney, Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Okay.
Without objection, it is admitted. Among other things, this states you are mentally competent in each of these cases to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied by the representation by your lawyers. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. We're going to have a pre-sentence report. Yes, sir. We're going to hold this in suspense. Order of pre-sentence report will return back on
January 5th.
January 5th. Good for everybody?
Yes, sir.
If not, let me know when you know something differently. Each side will have an opportunity to add information. And at that time, then we will allow family under the law to make any statements that they feel like they wish to make. But I urge, let's not make a decision until after the pre-sentence report is read, and then the state will get with the family and go over it so that y'all know where everything stands on the facts. But we want to make sure that it is accurate. The record is accurate as possible. And as well for the defense, the defendant has his constitutional rights and he has his opportunity to discuss this with his defense so that they can represent him fully and appropriately. Anything else to add at this time? If not, we are in recess on this case until January 5. Thank you. Please get a resetting.
Now we're gonna let it is.
Michael Lightfoot, Thompson.
Okay, sure, I already know that.
What are you gonna do?
Pass every question on trial, then.
Yes. We can agree with this. Okay. So.
That's all right.
If it rejects it today, it's not coming back. I haven't had a chance to talk to him.
Okay. I don't know when who will assign to you. Just they'll have to contact you.
Montreal Lightfoot. It said, look, way back when, it said a plea hearing. Some, there was talk about it before, y'all had to talk. So.
I've talked to this one.
And never.
You have two people who should probably.
This is a plea hearing document. This is set back on November 12th.
This day, Friday, has a social.
25 CR 715 is called. You were Montreal Lightfoot?
Yes,
Yeah, okay. Present with your attorney, Mr. Burbank, and the state's attorney. This states the plea docket states plea hearing, memo, possible plea. What's the status on that? Go ahead, Mr. Burbank.
This morning I conveyed the plea offer from the state, which is a 6-year cap to go on agree. And as I explained to my client, that you could not give him more than 6 years. And he could also be accepted for probation, deferred probation in this case.
Yeah, it's straight. Straight's about.
Oh, and straight. Both times.
Okay, anything else?
That's it. And after talking to you, do you want to accept that? Or what do you want to do, Montreal? Okay, well, that's a change from 30 minutes ago.
Well, I'm sorry, Mr. Lightfoot, what did you say?
Then you guys have him sit right here.
Okay, well, when y'all are ready, let me know. Thank you. Reginald Allison. Right. Okay, the right's not here. Let's see. We're gonna pass on stuff till he gets here. Gary Boudreaux. Mr. Matuska. Reagan Minaldi. Where's Reagan? I'm
sorry.
You're always here. Rafael Garcia.
Judge, I have spoken to him and I need a translator to help me with him. I've spoken with Ellie. She has one coming on the 15th in 2 weeks. If we could.
Who's the probation officer on this one? Come on out. On Rafael Garcia?
Yes, sir.
Have you had trouble at all communicating with him?
He understands very.
I want to know what she says. I know what you.
He does cooperate and listen every once in a while, but I do have occasionally, Officer Vega help me out with his, Officer Vega help me out sometimes, but he does understand when I'm telling him to report, when I'm telling him the things, and when we talk, he does seem to grasp the gravity of the situation. I'm very basic with him. I don't use big words.
Okay. Was he speak Spanish or something?
Yes, sir.
Okay. Is he a citizen of the United States?
Yes, sir.
He grew up in Mexico, Judge.
Nonetheless, there's you get to pass a test to be a citizen.
Judge, he was born here.
And he's born here.
He was born here, so he did not have to pass a test of any kind.
All right.
He's a citizen.
All right.
But
Welcome to America. But how old is he?
He's, I think,
19. Okay.
just with these complex issues that I have to talk with him about, I'm just requesting 2 weeks, but I can make sure that he fully understands
You got it.
everything.
Okay. Thank you. Thank you, ma'am.
Sir, have a good day.
Maximo Urbina. What does he speak?
English. He has informed me that his wife will be hiring another attorney. I don't know when that will be happening.
Urbina, bring him out. Yeah, Mr. Come on out. So you are Maximo Urbina? Yes, sir. All right. In 25 CR 53 here, this indictment, as you probably know, you have been indicted for the third degree felony of evading arrest or detention with a motor vehicle. And this occurred, it states in the indictment on or about November 6, 2024. That's a third degree felony, which carries with it, if convicted, no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing?
Yes, sir.
It doesn't end there. You have a rich criminal history. So in 2002, the state you were convicted of robbery out of Harris County and sentenced. Thereafter, that robbery was final. It is alleged you committed burglary of a habitation and were convicted of that in 2008 in Harris County, Texas. That right there, those two, robbery and burglary, place you in a situation where you are looking at habitual felon status. But looks like you have 2 other convictions after that. In 2016, you were convicted of evading arrest or detention with a motor, evading arrest or detention with a motor vehicle, which is interesting. It's the same type of crime you were charged with in this case. And also indecency with a child, you were convicted also on that same day. And those are out of district courts in Harris County. So you were a habitual felon 2 convictions ago. And here you are. So you're looking at no less than 25 years in prison to life in prison. Do you understand the punishment range that you face because of all of this? So with all that, he understands. What do we do?
Judge, he has expressed to me that his wife will be hiring him and a different attorney by the end of this week, isn't that what you told me? Okay, soon. She will be hiring a different attorney soon. Yes. Mr. Hand has extended an offer. We had discussions and that offer started at 25, which was the minimum of that habitual status range that he was looking at. Through discussions, Mr. Ham has agreed to abandon those enhancements and just give him 10, which was within the punishment range for a 3rd-degree felony. We've talked about those offers. He knows what that looks like, and I've explained that to him, but he, in our discussion today, he has expressed that he wishes to hire another attorney.
Yeah. Okay, so he signs an affidavit of indigence over a year ago. And one of the justice of the pieces here. It's
This is usually done intake.
no, I know that's not the point is then I only see 2 resettings in November and December after he was appointed. He for a year nothing happens for 1 year on this on Obama. What happened? I don't. There are no resettings except it jumps up to November.
Judge, he was bench warranted here from TDC. So I'm not sure what that process looks like in terms of
See,
He was sent,
he was indicted over well going on a year here.
yes.
And
Judge, he was arrested here, he was sent, it's just released to another agency. So someone came and got him out, he was only here for about 8 days back in November.
where'd you go?
24.
You know,
Montgomery County Circuit.
Montgomery.
And then
They sent him to TDC, I believe. And then he came here from TDC.
All right. Well, what we're gonna yeah. What we're going to do is he can get another lawyer, but I'm putting it on the trial docket. We're just going to default it over to the trial docket. No deal. Don't want a deal. I'm not going to get one. Let's try this case as soon as somebody can handle it. And if you hire somebody, that's great. Otherwise, we're going to move forward to trial. You understand? I'm not going to wait. It's been 2 months. It just waits around. And that's not the way we do things. We move forward.
I've advised his current lawyer that the offer that I extended is
revoked.
It's withdrawn.
Okay, so there is no deal now. We're just going to go to trial. We'll set it for trial, and if you can get somebody, fine, but they got to be ready to go to trial. I'm not going to wait around. You've had a year to get ready.
I was in custody.
Yeah, so what? You go and get a lawyer if you need to, but now you're asking for a lawyer. You're still in custody. Now you want more time. You've had a year. It's time to move forward. We move forward. We go forward, not lollygag. Okay? Set for trial. Set for trial. Set. All right. Crystal Vaughn. Bruce. Hello. We're on. Yeah.
Fine, yeah.
Okay, what are we gonna do? What are we gonna do?
Dr. Vaughn,
I know.
says that she's competent and I have had all kinds of problems, but I talked to her this morning and she wants a hearing on this motion.
Okay, when can we be ready?
It's only about non-reporting, Judge, so we can actually do it now if they want to.
Judge, I would ask that I have serious concerns. Every time I've gone to the jail, this woman that they report to me.
Are you Crystal Vaughn?
yes, sir.
Okay, you understand Mr. Smith is your attorney?
Yes, sir.
Okay. You also understand there's a motion to revoke unadjudicated probation that's pending? Yeah, I'm talking to you.
No, sir.
You were on, you
No.
don't remember being placed on probation?
Yes, sir, I do.
Okay, then back in July, the state filed this motion. Have you had a chance to review it?
No, sir, I have not.
Judge, I went out for the first time, went over for with her this morning.
This morning?
Room.
Oh, you don't remember doing that,
I wasn't in the jury room, sir, going over this.
ma'am?
I wasn't in the jury room going
Where were
over
you?
this. I was at the other unit, at the stalls unit, pay dorm.
You understand, but you understand there's a motion to revoke probation that's been filed against. You
No,
went-
sir.
you said you went over it.
No, sir, I did not go over it because I was not told that a logger was at, I guess, where were you at
All
the main court?
All right.
I was in
Let me
KA
help you.
dorm. I did not realize it.
Just
Let me-
I was there to tell
That's failed right there.
I understand, but
It's not
look,
fair.
Dr. Rapon has analyzed her and deems her to be competent. And
The problem that I have with Dr. Pond report is that he had previously examined her a year ago and reported that at that time she had been previously diagnosed with dissociative identity disorder. And she had also been diagnosed with personality disorder. When he did his examination on November the 4th with my client, she reported that she had no problems with any kind of mental health problems, which directly contradicts Dr. Papon's report. I have been out.
that's not, no, that doesn't contradict. It says, his report says she states.
I get
And then
she
you know
thinks
that, well, that's not what he concluded. I mean, but he concluded that she was deemed competent. So that's what's accurate.
Yeah.
Okay.
But if we're going to have a hearing, then I'm going to want to subpoena some officers from the jail.
Okay. When can you do that?
Well, I'm fixing to have surgery, and as well knows.
I don't really know much about, I know people, I had appendicitis once.
Yeah.
That's about it for
I'm
me.
having 12 inches for my colon.
How long is that going to take?
Well, I'm in pre-op all this week. The surgery is Monday,
And then what's,
and they say I'll be out at least 3 weeks then.
We may put some work at.
we, Crystal, well,
Yes, sir.
you might not be able to get to this for about a month. Is that okay with you? Or do you want to move this quicker?
And where would I stay in the meantime? I'm
You're
at
gonna head to
KA
the
dorm.
jail,
Huh?
in the jail.
At KA dorm, the where.
Yeah,
previously.
so yes, ma'am.
Yes, that's fine, sir. I would like to say
Okay.
though, in my defense, that I did report this to Mr. Anton at Bridge City, Police Department, where my car was vandalized and I was unable to report to parole. So I reported vandalism of my vehicle to Mr. Anton.
It's not parole, it was the probation officer.
Well, the probation officer, sir, but I was unable to make it. I couldn't walk from Bridge City to Beaumont or wherever it was, since I've been looking in trouble before. But I did report it. I also reported a break into my house at the same time where the keys were stolen from my Audi at the same time. It was reported to Mr. Anton. He actually wrote it in a little notebook, refused to do a report. However, after that, the people at the water department, you could actually call them as a witness. They knew. I actually approached them first about it. So they were witnesses, sir.
Judge, I just want you to know that the accusation
Time she report, when was she?
he's never reported is reason what I was trying to bring to your attention, Judge.
All right, everybody's talking at once.
What's about
She's placed in probation in May.
And you don't, hold on. I had two people and now you piped in as a third.
Well, that's,
This is a chorus. It's not a chorus, it's, solos. All right, first of all, Bruce.
She was placed on probation in May this year.
Okay.
The allegation is that she never reported to the
When was she
probation
put
department.
in jail? When was she placed in jail? Does anybody know? Jeannie, do you know when she was?
She was released from custody on May 28th, 2025.
And she was placed on probation, obviously the same day, but
No, when did she end up going back to jail?
when on the warrant,
This is fifth, I believe.
Mr. Menard made contact with her in Jefferson County Jail on August the 15th of 2025.
Do you remember when you were arrested by any chance? Do you remember the day you were arrested on this?
I believe she was arrested.
After you were put on probation?
Your Honor, she was arrested August 12th.
Okay, hold on. So August 11th is what we're showing on the records. So she appears here on May 28th. She's placed on probation on May 28th. Then we've got June 28th, July 28th, 2 months and a couple of weeks.
Yeah, there.
Okay. And she was to appear how often?
Your Honor, she was to appear at the probation office immediately upon her release or the following business day.
The next day. And, okay, so according to this, the findings here on this administrative hearing, the defendant was released from jail on May 28th at 7:05 PM, failed to report to the probation office the next day as required. That would have been May 29th, and has not made any contact with the office. So that's what prompted this is we go a little over 2 months and no reporting. I mean, when you're on probation, the first thing you have to do is report, and you just can't do it on your own,
My car broke down. An officer gave me a ride. From there, I reported.
No, wait, did you call? Who did you call with the probation? No, who did you
I
contact?
don't remember. It was on the paper. I don't have.
Do y'all have any?
No. I called.
I'm talking about.
No one answered. No one answered. So I called and I went over to
What time were you
the water
during the
department.
business day?
No, it was later.
At night, at midnight?
Yeah, and then I called in
You
the
called at
morning and then I
midnight?
went over to the water department because I was.
How about during the
they-
day? Did you call during the business day?
Yes,
When?
I think it was.
Let me just tell you, I've never had a problem in
Okay.
20 years. I contact them, somebody always answers during the business day.
Okay.
So. Well,
It could have been a reroute on the phone. I don't know.
you think so?
Well, landline.
Yes. Well, generally that doesn't happen, and we've got to kind of figure out what's reasonable with this.
Well,
But in
reach the
probation,
officer.
you have an obligation that you can, instead of going to prison, we gave you a chance to work through this during probation. And the foremost responsibility you have is to report. You have to do that. Everybody has to do that. If you don't, you're not on probation. It's just the way it is, simple. So you have an obligation, like all the probation officers have. You've got to figure it out. And the phones were, come on, we have to see you in person, and that's vital and necessary. But here you're flirting with 10 years in prison. Why would you do that?
For parole violation?
Evading arrest, or just you're on my probation for evading arrest, or do you not remember it? Good.
Evading
Good.
arrest,
We went over this. We went over this so delicately and deliberately. You're looking at 10 years in prison if you fail on this.
Okay.
One failure is something you could be revoked for. We hadn't seen you in months. You're supposed to be appearing regularly, or you're not on probation. That's the first thing. You got to show up. I don't know how you feel like you can't otherwise do that.
Vandalism to the car recording.
You got to call. We have every business day they answer the phone. Come on. I've never had a problem in 20 years. You're not going to be any different. The very first thing here, you've got obligations, and you've got 35 conditions here. But the most important is to regularly report so that they're supervising you. If you can't do that, then you can't be supervised, which means thus you can't be on probation. And then there's only one other option, and it's up to 10 years in prison. Have you ever been to prison before?
No, sir.
Good, you don't want to be. You don't want to go. You don't want to.
No, I'd like to see my grandchildren. I really.
They come in. They come in handy as wonderful parts of life. But this is responsibility that you have that can get in the way of all of that. And I mean, if you do it here, you would be parolable until 2.5 years were served. That's a long time not to see the kids. Anyway, what's everybody going to do right now?
I know, my argument is that and I truly believe, with talking to everybody that I have talked to, talking to her this morning and there, I truly believe that my client has been mentally ill. And this is
Dr. Grapon decides otherwise. Sorry, she can say whatever she wants out of her mouth until you can be the psychiatrist. All you can do is respond to what she's telling you, and the doctor knows better. And we're just going to. You've been doing this longer than I have, Bruce, and you know sometimes they're not forthright with you. Often your clients aren't. That's the way they were with me. Yeah, we all have. It's the way things are. The question is until Dr. Grapon deems otherwise, she is presumed competent.
You asked the question, what should we do? My answer is,
what do you want?
In my opinion, her failure to report is totally due to her mental problems, that I feel that she needs to be reinstated on probation and a mental health type of, so that she can receive the kind of help that she needs, because she is going to have a constant.
What's probation office?
Your Honor.
What did y'all think about it?
All I can base any statement on is what Mr. Menard had stated when he made contact with her August 15th of 25 at the jail. And he also noted a mental health concern.
Well, what should we do?
Other than that, we have no information on her because of the fact she had failed to report. We don't know where she resides. It sounds like she resides in Orange County. We can submit.
Is that where you live?
Orange County.
Is that where you live now?
I live in I live in the historic district in Orange, in the city of Orange.
All right. Because if I release you on this probation,
yes,
you've got to follow. You know, we're making a big deal about this. This is important. The foremost thing you have to do is report. Foremost, it all flows from there. Failure is not an option for you. You go to prison. Do you understand? That's where you would head up to 10 years. And the court, you have to report. If you don't report, you're not in the game. And you got to be in the game. So that's the very first thing. And you have to do is report as directed by the probation office. We're going to also, when you're going to be released, I'm going to release you. And the first thing you do is you go to the probation office if it's during the work day. Do you understand that? It is the first work day you're able to report when you are released. You go to them. If you don't, I will order a warrant and I'll say, we talked about this and shame on you. You know what you have to do. You follow their directions as well. Do you understand? You have to speak out. Do you understand that?
Yes.
So that there's not any confusion.
Okay, I don't have a vehicle as of this time. It's still messed up. It's in the front. Of
Where,
the-
where do you live? In Orange, you said?
Yes, I live in Orange.
Yeah, how do you
So
get
it's in Bruce City. I stay in Bruce City some. It's across
Okay,
the street from the water
but
department.
does somebody have a vehicle that that helps you move from one place to another? Do you have children or anything?
Yes, sir, but I would say I was going packing my bags. so
Ma'am,
I-
but is not an option. You've got to report. How are you going to do that?
I don't know without a vehicle, sir. That's what I
Well,
was
see,
trying
a
to
lot
get
of people
fixed.
who don't have vehicles, they still are obligated to report. Yes, Jeannie?
Your Honor, and what, the defendant is speaking of is one, Orange, if we tried to submit her case for courtesy supervision to Orange County does not offer a mental health caseload. However, they do have spinal tap services available in Orange County. But if her inability to even advise the court of where she resides, she can't reside in Bridge City and Orange. She has to reside in one location. Orange County will not accept that without one location being reside. And now she's just speaking of going out of state. We don't just go out of state.
No, that was prior to.
That's not what she just said, Your Honor.
I don't know.
I caught the same thing too.
I know.
It's in,
The more you speak, the closer you get to prison. I've got to be able to trust you to release you. Can I? I'm asking you, can I trust you?
Yes, sir.
To follow the, all right. You're gonna have.
Yes, sir, but I don't have a
You're gonna-
vehicle, so from where I'm just being honest. So you release me, do you release me from here? I don't know. I've never been in trouble before, so I don't know. So it's not being confrontational. I just,
Yeah. You're, we're trying to work with you here and you're kind of pushing back. You either are able to report or not. If you can't report, that's a problem. You have to be able to report, but you're on probation. You got to figure it out. Everybody does. We have 5,000 probationers.
okay, just, yes.
the question I've got is what happened with that Orange County? If she's under their supervision from that offense, it might assist us in resolving.
Bruce, on your, well, what did you figure? What'd you figure out on that other case that was pending in Orange County? Do you know what happened on that? You're charged with evading arrest or detention with a vehicle out of Orange County. Do you know what happened on that case?
Detention of a vehicle.
Yes, I just, okay.
I'm not aware of Orange County.
Evading arrest or detention with a motor vehicle.
Charged before and I was released and it was to probation. And failure to appear, I guess, for probation is a charge, correct?
No, I think he was phone call and find out for that.
Here's what we're gonna do is we're gonna figure this out. I'm gonna
vehicle.
reset this for a week. Okay, I'm gonna reset this. And there's a lot of gaps that aren't being filled out.
As well.
Ms. Vaughn, you
Last time I checked,
try
it
to
hasn't been died.
give us information that is helpful or not, but you're acting like you don't even know anything about yourself. And we'll figure it out.
I
But
do
it's
know
gonna
about
take a while.
I read
And you
the
can't help
details of the
you can't help but
vehicle.
interrupt people, can you? That's even rude. We learned that first. We're gonna see you back in 1 week. Thank you. All right, did you have anything else, Bruce? Bruce, did you have anything?
The only thing I had to do was on the trial, I was that Aaron, Tyler, and I filed that book with keeping student search.
All right, done. You got it. Good. Hey, Brent, Donald Barnes.
No, that was Paul. Oh, yeah. I'm going to be representing him.
Who? Hey, let me see his two cases. He's on bonus.
Actually representing him on those issues.
We have a motion to revoke probation. And in 23 CR 826. And we have looks like a new event. No. No. Okay, there's a motion to revoke probation that was filed on a drug case as the defendant was placed on 10 years probation in June, and it is alleged that he committed the offense of illegal possession of a controlled substance. I don't even know what that is, though. It's not listed here. Sure. We may need to amend this. And then associated with a disreputable person. All right. And then we've got a pending. Well, I'm sorry. After that, the defendant is indicted for an event that happened in August of 2024.
So that actually predates, the offense predates his probation in that new matter, and how we dispose of that is going to turn on what we're doing with the probation. The new offense is alleged there.
Well, the motions always go first.
Right.
So you're going to come in on this,
Yes.
And then when can we be ready for a hearing on this?
Well, Judge, on the new law violation on the motion, I'm not talking to Mr. Ham, but we're trying to check into that, what was going on. I don't know how much time.
We need about 30 days, Judge. So I need to track down what's going on, why we haven't received that offense yet.
4 weeks. All right, we set 4 weeks for the hearing.
Hearing.
Thank you. And that's on that MTRP.
Yeah. Yes, sir.
That's pending. Okay, Ashley McKinney.
Judge, if we have this more stuff in the trial docket for a plea, she in the queue someone?
Yeah.
Okay. She's in Miss McKinney's in the package. So.
Talk about Carson Moore.
Sir, she's gonna be a lesser assault.
Or should we do that first or?
Yeah.
Okay, I need, more to come fingerprint. Yeah. Where's the right hand? Just for all kinds of stuff. This is stuff you got, or you have your right hand first. Place it flat right down the box. You get one more box. It's right there.
Yeah.
Yeah, stand in front of judge.
She's doing the Jamie.
This is Nora.
25 CR 40. 25 CR 497 is now called the State of Texas versus Carson Moore. Is that you?
Yes, sir.
Present with your attorney, Mr. Turpin, state's attorney. Does the defendant with a formal reading of this indictment and arraignment, can we proceed in silence?
You have a, she does.
In summary, this indictment alleges that on or about February 14th, 2025 in Jefferson County, Texas, you committed a second-degree felony of assault on a peace officer. Do you understand what you're charged with here?
Judge, let's make sure we're clear. She's going to be a lesser included assault.
Do you understand what you're charged with in the indictment?
Yes, sir.
All right. That would be a second-degree felony. You have an agreement that I'm looking at that states you would be pleading guilty to the lesser Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Is that your understanding?
Yes.
You're looking over at him. But you understand the punishment range and what the plan is.
Yes, sir.
Okay. An agreement has further been reached. You would be pleading guilty to this Class A misdemeanor and something based on 2 years deferred of unadjudicated probation. Correct?
Yes, sir.
So if I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. The states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your right to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. Are you totally satisfied with the representation provided by your lawyer? All of this is true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report, right?
Yes, Judge.
Multitasking here and writing on the indictment. He has pleaded guilty to, which is the lesser included class A student. All right, I'm going to follow this agreement and find you are mentally competent to enter this guilty plea to this lesser included Class A misdemeanor of assault. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this lesser included Class A misdemeanor of assault. However, I'm going to instead defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation for this misdemeanor assault, and not the least of which is you shall complete an anger management program. That's the right, which helps you make cool choice decisions when you're under pressure, which I think is behind all of this. And other terms and conditions of probation. Make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. Okay. You understand what's happening? They see the probation office. Okay, where were we on Ashley McKinney?
She has two, the MTRP and the new case that's relatively young.
Where's she?
She's in.
Do we need her out? What's gonna do?
She's hung up. She doesn't want to do the same thing to offer it.
I don't care. Let's just go do the process. Let's just take care of this misdemeanor first. This motion to revoke, and then we'll go to the other thing.
Let me ask her what she wants to talk. What did you want to do on?
Do we need her out?
Probation's in agreement with what I've offered you.
Okay.
It includes the 10/10 on this offense and dismiss the state judge felony. That's a year on it.
Okay.
There she comes. Are you Ashley McKinney? Come on up in 25 CR 292, ma'am. By the way, you're here with Mr. Turk, your attorney, the state's attorney. Probation office is here. You were on probation in clause number 25 CR 292. Class A misdemeanor, lesser included Class A misdemeanor of theft. And there's a motion to revoke probation that's been filed alleging 7 different violations, not the least of which committing the new offense of theft of property, providing urine samples showing marijuana and methamphetamine in your system, failing to work faithfully, to successfully complete the substance abuse assessment, failing to report properly to Tyler counties if we allowed you. I guess that was a foolish thought on my part. That was a waste of my effort. And failing to report to Jefferson County. That is all under this motion to revoke probation. And you were looking at up to 1 year in jail based upon the disposition of that, which we'll do first. Then you've got a new indictment in 25 CR 1293, which alleges that you committed the second-degree felony of illegal possession of methamphetamine. But it also alleges you have a prior conviction next door out of the 252nd District Court for illegal possession of a controlled substance in 2022. And so if all of that was proven true, you're looking at first-degree felony punishment. You're looking at it for life imprisonment. So that's where we are. Now, here's the first thing we'll do is get the motion to revoke done. And then I'll just, I guess, set this for trial on the other. And is that what we want to do? All right. Then that shall be done that way. I don't hear anything. You don't have time to talk about this. That's what we'll do. We can just, y'all get ready for this motion to revoke. Y'all horsing around. Come on.
We'll get it done, Judge.
It's going to be the way it's going to be done. Y'all have a chance to fix this and figure it out. Don't do it here on the. So Marcus Miles was reset. Then I have Edward Atremba. Yeah. Yeah. That's true. Just give me something because I do say James was supposed to be. That's a lifetime ago.
That just went a little weird. So,
And that's for a third degree?
Yes.
Okay.
something else.
Come on up. Here he comes. You're Edward Atremba?
Yes, sir.
All right. Mr. Atremba, been a while here. You were placed on probation here in this court.
Yes, sir.
Going on 10 years ago. It'll be 10 years ago. And you on February 8th of 2016. And you've failed to report, according to this motion to revoke probation, in June of 2016. Upon you were required to meet with the probation office upon release, and I guess that never happened. He was released from custody, and then almost a decade goes by. You have to figure out that we did something up here for probation for some purpose. Because I signed this order placing you on 5 years probation on February 8th of 2016. So it's alleged you never reported, I guess, ever. And then they filed this motion in August of 2016 and finally stumbled upon you a decade later. And here you are now.
Yes, sir.
And Mr. Turk is your attorney. This motion is pending. And what we'll do is hear this thing as soon as y'all can be ready.
Okay.
Well, can you be ready?
Next week.
Yeah, let's do it next week.
This is easy, Judge.
Okay, we'll set that for next week. And thank you, Gregory Woods. Gregory Woods is next. Thanks. You're doing a fine job.
This is very exciting.
That was just smooth, complete. It was the smooth working of the door.
Very exciting.
Used to be my job, you know.
I just. Yeah, so. Information. Yeah. I know, no. I'm just.
Hold the ruckus down. I can't hear up here. Well, y'all watching a ball game?
This is tree lighting.
Oh, the tree lighting?
We're mixing
We're up here.
party, yeah.
We're up here. Everything's going on there. Okay, you're Gregory Woods.
Yes, sir.
All right, you were here with Mr. Turk, your attorney, and the state's attorney is present. Earlier, you pleaded guilty to credit or debit card abuse involving an elderly victim. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
Stuff was in the defense to us.
Judge, there was a letter that's on the last page that appears to be from a different defendant. If you look at the name on the back, that's not this defendant. Okay, it's on the back of.
You mean this one's purporting to be Colton Armstrong?
Yes, sir. That's not this defendant.
I didn't get a copy of that, so I was unaware of that.
Here, we can get this back to the probation office and it must go to another defendant, and it says it's written to Judge West. Otherwise,
As far as I know, we're good.
so. Yeah. There's probably any type of theft-related offense that's any worse than victimizing an elderly person, right? Would you agree? That's what you're wrong with, though. That's what you got to. This person is 77 years of age, which dropped a bag that he carries that contains debit and credit cards, personal belongings, and a Ruger Magnum 5-shot revolver. This occurred at Lowe's Home Improvement. And as soon as he discovered that, he canceled his cards. His Third Coast credit card was not canceled, and he began getting notifications from Third Coast Bank that purchases were being improperly made. I guess that's what you were up to. And it showed it all traced back to you. And a video also was recovered showing you making the transactions that victimized this person. And let's see. I left out of Walmart. There was a Lowe's parking lot. I found a backpack. I looked around and kept it. That's what you said. You did more than that. You misused the credit cards, right?
No, I was looking to see if somebody was there.
Somebody lost a credit card. That was you, right? That was using it? Sir? Well, you knew that was wrong. Wasn't that, you knew that wasn't you. They don't give free money away. You know that. Says $4,000 was somehow taken from the plaintiff. Looks like you somehow acquired $300 to $400 in cash. I don't know where's the rest of that loss came from. So his cell phone and other credit cards and the handgun were never recovered. According to the district attorney's office, $1,531.68 is requested in restitution. $1,531.68 should be paid to third close of credit, and $2,468.32 paid to him. That totals $4,000. So what are we gonna do?
Judge, Mr. Woods would like to receive probation in this, and what he's asking the court to do is, as the court noted earlier, one of the worst things you can do is doing with an elderly person, but Mr. Woods at that time, when he made the poor decision to take it back, he did not know the age of the owner. He did make a bad decision in using the credit cards and contents of the bag, but he did not know the age of the person that owned it. I don't think he probably knew it until probably he got arrested for it. He has also had a pretty serious car wreck earlier this year, which requires, from what I gather, some extensive prescription regimen. He's waiting for benefits from Social Security and whatnot. He can only stand for 30 minutes, as noted in the PSI. He can't lift a whole lot of weight, so he's got some disability issues. He was in a coma apparently for 3 weeks. His criminal history, while it's pretty long, he hasn't had anything really of felony within like the last 10 years. What Mr. Woods told me, his last time felony-wise, he actually said he owned up to what he did and he wanted to take the time instead of drug treatment. So he voluntarily went into his last one. So in 2014, that was the explanation of that particular felony. And it's been about 10 years since that happened anyway. And since then, I think there's been some note on some misdemeanor issues, but for the most part, he's been doing what he's supposed to do. He made a terrible mistake in keeping the bag in Lowe's. There's no excuse for that, but that's why he's owned up to this, and he's accepted that he's pled guilty, Judge. But he would really like to be put on probation so that he can make the restitution payments to the bank.
How's he going to do that?
I think he's going to get disability from Social Security.
Oh. Let me ask you this. Out of all your convictions, when did you ever pay anybody back? Ever.
Yeah.
How many, let's start, how many convictions do you have? Let's see if you can guess correctly. It's your life.
Like 4.
Sir?
Like 4 or 5.
Is that your final answer, 4 or 5? Okay, let's count these. Let's see. We've got misdemeanors, willful obstruction. I don't even understand what this means. LEO. Law enforcement officer, I guess, out of Newton County, Georgia. 12 months probation in 2008. Criminal trespass, also 12 months probation in 2008 there in Georgia. Resisting an officer, 28 days in jail. 19, resisting an officer, 28 days in jail in second case out of St. Charles Parish. Class B theft in 24, 9 days in jail. Evading arrest or detention in December 24, 24 days in jail. Failure to identify in 25, 30 days in jail. So what is that? 1, 2, 3, 4, 5, 6, that's 7. Let's go to the felonies. Burglary out of Lafourche Parish, Louisiana. You got 5 years in 2005. That was revoked in 2012, and you got 3 years hard labor. Then criminal damage to a coin operated machine, 3 years probation in 2004. That was revoked also in 2012. Then you got 2 years criminal damage to another coin operated device. That was revoked, and you picked up 3 years hard labor in 2012. Another 2 years probation. You received 3 years hard labor. It looks like you picked up 4 convictions in 2000. You were placed on probation in 2004. Those were all revoked, and you get revoked in 2012 and 3 years hard labor. So that's 4 more. That's 11. Then you've got 10 years probation. That was revoked for controlled substances. That's 12. Then Monetary instrument abuse, St. John Baptist, 5 years, revoked, received 5 years in prison. In 19, a second revocation of probation in 19, you get revoked out of St. John the Baptist Parish in Louisiana. Then convicted of monetary instrument abuse in 2016. And principal to attempted theft. Those are all convictions. So I've got 1, 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 convictions. Not quite the 4 or 5. Not quite 4 or 5, is it? All right. There's no way you'd ever pay anybody back. We all know. You've never done it in the past. Okay, so the agreement here is whatever sentence shall not exceed 5 years in prison. So you're looking at no less than 2, no more than 5 years confined in prison. He could be placed on regular probation, sentenced to 5 years, and that would be suspended, and he could be placed on regular, sentenced to 5 years, placed on regular probation for 5 years, and 5 years deferred or unadjudicated probation, I guess, what we're talking about. Although when we have a cap of 5, how do we work that? See, on a deferred, do they get, can I assess 10 years deferred? Maybe, I guess. And that's a cap of 5 years imprisonment, right? So you can't give imprisonment more than 5 years, I guess, is the way that works.
We could argue.
What's that?
Judge, the state is going to ask for the 5 years prison. When it comes to the offense itself, this defendant made 12 purchases at 9 stores over the course of 2 days. So it was a lot more than just seeing a backpack and keeping it. He did a lot of damage over 2 days. The court also just pointed out all of the convictions the defendant had, even when he was given the chance of probation. On several of those times, they all resulted in revocation. So it's obvious that this defendant cannot do probation, let alone be responsible for paying someone back. If you also look at several of the charges, Judge, they also either directly or indirectly relate to theft. So for example, his monetary instrument abuse.
I understand. I agree with you.
Okay. And lastly, defense counsel, I believe defense counsel pointed out defendant not being in trouble for a couple of years. What I see here is in 2014, that for monetary instrument abuse, it says that it was revoked in 2019 and he was sentenced to 5 years DOC then, which would account for why he hasn't been in trouble for a few years. It wasn't by his own choice. It was because he was in custody.
Somewhere.
Actually, I believe that was when he chose to do time for him. So he chose to go.
Right. So, but I'm saying that that's what kept him in trouble for choosing to go and do time. So I'm asking us to sentence him to the full 5 years.
Go ahead, defense.
Judge, I mean, as I pointed out, I mean, earlier, it's been 10 years last time and he had real issues. He owned up to everything. He went into prison on his own accord, did some time. It was a poor choice of picking up the bag off the street. He acknowledges that by virtue of pleading guilty, and he's asking the court for a probation.
Anything else you want to say, sir?
Yeah, well, I wasn't out looking for trouble, man. I just found her. Just ended up running into it.
Wasn't your fault, it was somebody else's.
No, it was my fault. I own up to it. I did it, but I wasn't out looking for trouble. Last time I was in trouble, I gave myself over and died. And I
So 17 separate times trouble has found you without you looking for it.
That was when I was drinking and stuff. I stopped drinking since my last conviction at 14.
Anything else?
Oh, no, I just recently lost my mom Monday. Her funeral was Saturday. I'm just trying to get out.
Well, yeah, that's what happens. Life goes on the outside. That's why it's always a good idea. If you make a mistake, you fix it. You've made 17, you can't seem to fix. And here we are with another big one. Earlier, you pleaded guilty in this case voluntarily, sir. to credit or debit card use. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of credit debit card abuse of an elderly person. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You shall, in the judgment, it shall be reflected that restitution is owed in the amount of $1,531.68 to Third Coast Credit Bank and $2,468.32 is owed and payable to the other victim, in this case, Clarence Holland, as named in the indictment. Those shall be part of the record in the judgment and ordered to be paid. Anything else? That is all. John West, I have Jessica Robinson.
Sure, she's in the back.
What are we gonna do
I believe we're gonna let you decide what to do.
today? Okay. Jessica Robinson. Yes. Please.
It's administrative violations. It's just the next time.
I have a Corey Hillman, Montreal Lightfoot, and Christian Simeon, right?
All right.
Okay, you know what? I'm gonna hold her in the, hold her and then let me take care of these. Who do you have, Tom?
Montreal.
Come on up with Montreal.
Judge, the Woods file, please.
Right. Here it is.
I mean, if you're like, in front of me. Raise your right hand, you swear or affirm to tell the truth and nothing but the truth, so help you God? Okay, you can right thumb. Yeah.
I don't know. That's the big.
Okay, place the flat right there. That one more time.
Think we can move about four.
25 CR 715 is now called Montreal Lightfoot. That's you, sir?
Yes, sir.
President, would you? Mr. Burbank, your attorney and the state's attorney, does the defendant believe a formal reading of the indictment and arraignment? Can we proceed in summary?
He does, you may, Your Honor.
In summary, this indictment alleges that on or about May 5th, 2025 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct by knowingly discharging a firearm at or in the direction of an individual. Do you understand what you're charged with here?
Yes, sir.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached. In your case, you would be pleading guilty. Whatever sentence shall not exceed a cap of 6 years in prison. Is that your understanding?
Yes, sir.
We're in cap field now. That's what we're all doing, caps. You're looking at no less than 2 nor more than 6 years confinement in prison. 6 years, I guess we place you on deferred or unadjudicated probation. Also, you could be sentenced up to 6 years in prison, and that could be suspended, and you could be placed on regular probation. Is that right?
It depends on if it's just a G.
It's not a 3-2 check.
Then you can.
I think those are your options. I'm not sure a jury can give the regular probation for it. I can't.
Well, I think the zero can judge on deadly conduct.
On deadly conduct, it's available from both sources, Jeff. Now, should you or a jury?
Well, it's alleged that deadly conduct, that a deadly weapon was used in the commission of this offense. How can a jury give probation? I can't. I don't think they can.
It's not one of the 3 Gs.
Yeah, it's not a listed 3G offense, excluding it from a jury judge. If the court makes a deadly weapon finding, it will restrict what you can do. But my understanding is that a jury can give probation on this offense.
Right down the box, roll it. Or raise the flag, yeah. Okay, you can go one more time. Good one. Okay, let's do it right there. You can have a seat till the 12 minute, okay?
Fun thoughts. I know this is that. You have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you here what's marked as State's Exhibit 1. Did you sign that document? Voluntarily. Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This states, among other things, you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to your jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is part of the record for all purposes. We need a pre-sentence report on this. And we're going to order this returned back on January 5. Everybody can add whatever additional information you want and then make arguments, and then the court will make its decision. Okay. Anything else? All right, thank you. Good luck.
Thank you very much.
We now call 24 CR 1242, the state of Texas versus Corey Hillman. That's you? You have to speak out. So you shouldn't. Presently, Mr. West, your attorney and the state's attorney does the defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment, which was handed up on June of 24, states that on or about May 7th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you were charged with here?
Yes, sir.
If convicted of a third-degree felony like this, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you are facing, sir?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 6 years in prison. That would be suspended. You would be placed on regular probation, which can be up to 10 years in length on the probation. Fine $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this third-degree felony of evading arrest or detention as charged in this indictment? Guilty or not guilty? I just ask a question.
Yeah.
Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes, sir.
Okay. That was a pregnant pause there. Show you what's marked as State's Exhibit 1. Did you sign that? Understanding. Discuss it with your attorney or the contents true and correct.
Yes.
State's Exhibit 1 is tendered into evidence. Without objection admitted. This states, among other things, that you are mentally competent to enter your guilty plea freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, this states, so help you God. Is that so? States Exhibit 1, part of the record for all purposes. Please send your report this way.
Please, Your Honor. Yes.
Anything else to add, State?
No.
Our defense.
The only thing is, as we did, I know it's a discretion on the amount of probation, but we, through negotiations, agreed to 6. I just want to make sure I was aware of that. Yeah.
Anything else?
No, nothing. No.
If not, then I'm going to make the findings that you are pleading guilty, sir, voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1, admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. That will be suspended. You are placed on regular probation for 6 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You will be fined $500, among other things. You're going to have to successfully complete a defensive driving program, which is a win-win because your insurance will go up because of this, but will go back down for taking defensive driving. So it's a kind of a quid pro quo equitable remedy there, but it is normal and customary for this type of offense for that as a condition of probation. And there will be other terms and conditions that are normal and customary. Please follow them. If you fail, your probation could be revoked. You could be sentenced up to 6 years in prison. So fix this. Probation officer is going to talk to you and go over those. You'll review them and sign them and begin probation. Good luck. Yeah. Christian Simeon. 24 CR 777. That's good luck. In Haiti, I think. Is called here in this case. You are Christian Armani Simeon, correct? Here with Mr. West, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed to summary?
Yes, Your Honor, please.
In summary, this indictment alleges a most serious charge that on or about March 5th, 2024 in Jefferson County, Texas, you committed the first-degree felony of aggravated robbery with the use or exhibition of a deadly weapon, namely a firearm. Do you understand what you're charged with here? If convicted of a first-degree felony, you face a term of life in prison or any term of years of not more than 99 years in prison or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
Going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, the states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You're read. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true at state. So help you God.
Yes, sir.
State's Exhibit 1. Are the record for all purposes. Pre-sentence report is waived.
Yes, please.
I'm going to follow this agreement. Stand by just a second. Okay. All right. Looking at this probable cause affidavit. So, okay. So 2 people, this defendant and Javon Sims go to get a haircut from somebody. And then according to this probable cause affidavit, Sims displays a rifle, demands a firearm that is owned by the person who's going to be given the haircut. During this incident, the defendant is in the bedroom attempting to steal the victim's gaming system. And at this point, the victim is in fear of his life, presents pulls a firearm and shoots the Sims, and then both subjects escape. Sims gives a confession that he did commit the act of aggravated robbery, and then Simeon here was with him. Okay, all right. That's all they said. There's not a lot of depth here, you know, so.
That's why I deferred was offered in this case.
I understand.
Yeah.
But in conditions of probation, what this court normally does is I put people in jail for up to 106 months, which I can do as a condition of probation when there's an aggravated crime that's being committed, especially when you're, this is all too often a problem. And that's why this court does what it does. And I say, you commit a violent crime, you're going to jail. You just go to jail. You made it, you've signed your contract. That's what happens. You're held accountable, and deferred or unadjudicated probation includes confinement up to 6 months. What's the state say on it?
Judge, if the court finds that that's appropriate, an appropriate condition.
Whenever an aggravated robbery is committed.
I would argue against it for the sense that he's not the one that had the gun. If he had the gun, then I would not argue it at all.
Did he commit aggravated robbery as a party?
Just by law parties, because he was there with it.
Just by law parties, but I mean, the legislature enacted that for good reason. They just don't include people who are in the area code.
I know.
He had an affirmative act that he took part in, knowing that it was going to, that whether he held the gun to the guy's head, whoever's holding it to somebody's head,
right?
They and everybody helping that person are held accountable.
I understand that. My other argument in this case is Mr. Simeon has been on bond this entire time. He has never missed court. He's never had a problem.
But that all did not prevent him from committing a crime. He's not going to be punished for being good on bond.
I know, but I'm saying there's other factors I think the court needs to consider, that this is a little different than a lot of times what we see. And I understand the court does do this a lot of these cases. And like I said, if you have the gun, or actually the primary, I don't want to use the term primary, but the person had the gun, I wouldn't even be asking anything of the court. I know what the court would do. But I think it's a different situation. He was there. This whole thing went down. I don't think he ever knew this was going to happen. At least I've talked to him several times. He had no idea this was happening or going to happen. It wasn't intentional, or didn't go there with that intent. But it did happen. He was part of it.
How was he part of it if he didn't have intent? You're about to talk out of a deal. You know that.
I know.
He either committed the crime or didn't. And he had to have a culpable mental state to go along with the law parties. He helped him or not. What did we do? If you didn't help him, you didn't. We're going to trial. We'll let a jury try it. You've said enough. You know what you just said. You've walked this thing out of the.
Let me finish. I haven't finished the rest of it, Your Honor.
Yeah.
I didn't say he didn't go there with the intent to armed robbery, the intent to steal the item, which actually did happen. We know that. Okay, that's what we talked about. But then the gun got pulled. I don't think he knew that the gun was going to be pulled, but he still went along with it and still continued with the process.
How did he do that? How did he get involved in the law of parties for aggravated robbery?
Because he was the primary person. Mr. Sims was using the gun to steal.
He had to
apparently a gun. Okay. Okay.
But what that said,
he was stealing out of the other room, stealing the gaming system. It was Xbox, right? Or was it PlayStation? Right. The gaming system, and then it all evolved from there, Your Honor. Then
let's read the law of parties just so you know what you've done here.
And if when the gun would pull up, he would have walked away or stopped, then he would be out of that. But when he continued on with what he was doing, that includes him with law of parties.
Mere presence of the defendant at the scene isn't enough, but it is circumstance combined with other facts that may show that he was a participant. He is criminally responsible for an offense committed by the conduct of another if, acting with the kind of culpability required, he causes or aids a person to engage in conduct, acting with intent to promote or assist the commission of the offense. He solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Okay, culpability is all part of those.
Yes, he was
But he didn't do any. He wasn't there to do anything.
I think they were there to steal stuff. I don't think he initially knew that there was a gun involved, but he didn't. When
He
the
had to
guns came out-
solicit, encourage, direct, aid, or attempt to aid the other person to commit the crime of aggravated robbery. What did he do to help commit the crime of aggravated robbery?
items. While the guy had a gun out, he was taking items. Therefore, he becomes part of it. I'm just saying that I don't think his intent when they got there was to use a gun and they were going there to steal stuff, sure. But when the gun came out, he didn't abandon it, which would at that point.
What did he do other than just be present? What is it that, what affirmative acts did he take?
With the other guy
Part of the
having a gun.
robbery.
Yeah, he was taking items. That's part of a robbery. When you're taking items that don't belong to you.
Could you go over that again? I guess I was slow in school. Is that right?
He was
No,
committing.
I'm just kidding you.
I know. He was taking
No,
items.
he's got to have a culpable, he's got to have a bad mindset.
Taking stuff
So
was
what
a
did
bad
he
state
do?
of mind. Stealing stuff from people is a bad state of mind. And then when the gun came out, he didn't.
Did you know he was going to rob the guy or not? Surprise.
Yeah, I agree with my outfit just because he came there with me. Was
That's the only reason.
he was my friend, so he came to me, so I'll take the blame for that. Because if I would never brought him, nothing would have happened. Since I brought him with me, it's my fault.
It would, okay. You're pleading guilty because you think you were a friend of his because of your friendship.
Oh, no, sir.
Yeah, that's not the test. You have to have done some bad things as part of this crime of aggravated robbery.
Yes, sir.
What did you do?
They claimed that I grabbed things.
No, well, I don't care what they claimed. What did you do that was part of the robbery, sir?
I didn't. I was in the bathroom. I went to go grab a lighter. Then that happened. Two people didn't like the way each other was looking. Then that happened. I heard a gunshot out the house. Like that. So
Anything else? All right, we'll set it for trial. Okay. That's all we can do. No, he doesn't, the record didn't support it. He's not admitting guilt or culpability here. It'll be set for trial. We'll let a jury decide your fate. Okay. And they don't give probation. Anything else?
Sure.
That is all. No, it's set for trial. You talked yourself out of, you're not responsible. You're not guilty. And that's what you made it clear. We can't accept a guilty plea when it's not guilt. You didn't do anything wrong according to you, except steal some stuff in the other room. It's the other guy's fault. So we'll let a jury decide. We'll set it for trial. All right. That's all. Thank you.
I'll email Gretchen. That's me. I'll email her. I'll talk with his mom.
Joseph Castillo. That's all. What are we doing?
Judge, I believe we're set for the bond hearing today. Mr. Castillo's in custody.
Bring this Castillo out, please. When are we going to have a hearing on this motion? Can we do it next week?
Yeah, it's all administrative, Your Honor.
Are you be ready next week?
Yeah, sure. We're not in trial on that other case.
We'll try. We'll see what we can do.
Well, hang on. I say that, but I need to get some records from Spindle Talk, but I can subpoena them to appear in person and such. I mean,
Castillo, Mr. Joseph. Come forward here on this 19-3170A. There's a motion to revoke probation that's been filed, which alleges that you have been placed on deferred or unadjudicated probation for the state jail felony of illegal possession of a controlled substance. That was in 2019. What's happened? Was he an absconder?
He violating was taken out of the safety.
He relapsed, John.
We sent him to safety and then he came back, he relapsed, we sent him to safety.
No, hold on.
relapsed.
He was on probation for 5 years
You
since
extended-
2019. Oh, it's not showing that it was extended.
You extended it on June 10th, 2020.
Okay, because the way this reads, he completed probation 2 years ago, actually, yeah, 2 years ago, right at 2 years ago, according to this, because it doesn't show anything about anything past 5 years deferred, which would have ended in 24. Is that right? Your probation was extended? For how long?
2 years, Judge.
All right. So it alleges you failed to avoid disreputable people by being around those actively smoking marijuana. If you provided urine samples that showed the presence of drugs, urine samples showed the presence of alcohol, urine sample, cocaine and tetrahydrocannabinol, failed to submit to alcohol and or drug screening, failed to pay court assessed fees as directed, failed to enter and successfully complete the substance abuse felony punishment facility back in July of 24. There's 8 different violations. Only takes one or more for the court to find that you've violated the probation. You could then be found guilty and sentenced up to 2 years in the state jail. Do you understand what you're facing? That's right. Okay. All right. So what are we going to do?
Judge, what you just asked when we would be ready. Again, I do need to make sure that we have Spindletop available to discuss mental health records. Aside from that, I believe we were set today on a bond request. It's unadjudicated probation. I understand there are concerns if the court did proceed with instituting a bond. The concern from a perspective of the mental health caseload is whether or not his conditions are being adequately addressed while in custody. And so I think that's going to have to be better explored. Obviously, there is no.
Why don't you do that? You're going to represent him. I'm not going to be able to figure that out. Isn't that your concern? Because I'm going to listen to whatever you have to say. What do you have to say about it?
About
what do you want me to do?
Concerns? I'm asking for a bond, Judge. I thought I had made that pretty clear.
No, I'm talking about his mental health concerns. What is it you want me to do?
As far as his mental health concerns right now, I don't need the court to order anything.
Okay. All right. What are you asking for here? Exactly. Just a bond of any amount.
In terms of an amount, what am I asking for?
State, what do you have?
Judge, I'm concerned with all these positive drug tests and the fact that safety doesn't look like it worked. So I would ask the court to, whatever bond you set, to take that into account, specifically for his own safety. As far as I'm concerned, when he's out there, he's using drugs. I can be ready quickly. I would rather it stay at the state that it's in now. These are administrative violations. The state's ready to have a hearing.
I know typically when there's a bond issue on a motion to revoke deferred, it's usually anywhere from 1/2 to twice the original bond.
Never look at that. We look at what's new.
I think
probation and what he's done, because those are all new. That has nothing to do with the original bond. It's how he performs. That's new information that is part of the calculation. Oh, where you got that?
I wrote down in my notes that this young man is lucky to be alive. Just looking at all the drugs that he's been using there, I don't want to take the chance that he's not going to be here for a hearing.
I've worked with Mr. Castillo for some years. I was his QMHP at Spindletop. He's been on the mental health caseload several times. Since being his probation officer, he came back from St. Pete. He relapsed less than a month later, went back to St. Pete recently, 30 days, and he used while he was there. And since he's been home, he's tested positive for barbiturates, THC, cocaine. When he's not taking his medicine like he's supposed to. And we've talked about that. We've discussed that. He's diagnosed with schizophrenia. And he knows that when he doesn't take his medicine, he starts drug seeking. The last time he tested.
Are you getting your medicines? Okay.
In county, I'm getting it about 2/3 of the time. And
what's the?
They're not giving me the afternoon dose.
Sir?
I'm not getting the noon dose. In about 30 minutes, I'm not getting.
Do they know about it?
Yeah. Yes, sir. Yes, Your Honor.
Did you tell your attorney?
We were just able to talk for the first time since I've been locked up a few minutes ago.
Yeah.
Things have been fairly rushed.
I'm sorry, you've been locked up a few minutes ago?
I was only able to speak to him since I've been locked up a few minutes ago.
How long have you been locked up?
About 2 months. Almost 2 months.
He's not seen you in 2 months?
Yes, Your Honor.
Okay. About that. What are you figuring out? What do you need? I mean, does he need some medicine?
Well, I know that he was previously on Cogentin.
And what about right now? What do you know about him? You hadn't seen him in 2 months, but what do you know?
As far as what he's presently taking at the jail, I don't know.
Can you figure out? So we know he's getting medicine?
Yeah.
Like he should?
Thorazine, Buspar, and benzotropin.
Sir?
Thorazine, Buspar, Buspirone, and benzotropin.
When you're getting the medicine, do you feel okay?
Normally, yes.
Okay. Anything else, Dan? Then his bond is $20,000. If you post your bond, you need to have a drug patch as a condition of bond so that we know if you're using any drugs. And that it has to be done as a condition. Then you have to be taking all your medicine as a condition.
That's right. Yeah, the probation officer tells me that at least one of those positive tests was on a drug patch when he was on probation.
Failure is not an option.
That's right.
I would do it, but anyway, I'm setting this for a hearing next week.
That's right.
Thank you. All right, that's that. I have Tara. It's like
Pictures are all of Bryce's clients.
We saw that. Yeah, yes.
These are all on, that's the TRPs, you could go through the TRPs and see your
It's all or nothing. We're going to do everything, but we'll do it.
Pretty simple.
Yeah, the PW9 and then that doesn't help us. We can't take kids in installments. We got to do it all. But I'm going to set this next week. If there's yet next week.
Let's see if you can set it on. If you have the probation.
Just checked our system, Judge. We still haven't received the new case, the DWI. Let's see underlying cause. I need to do some checking to see where that's at.
That may have made companies. Yes. How proud. Yeah, that's it. I'm not sure.
I think she's on this today. I think she's on this today on probation.
It's just this. I don't think it's gonna file in this board, so, but it's.
No, you go probation.
All right, 24 CR 577 is called your Terra Hawk property.
Speak up.
There's a motion to revoke unadjudicated probation here, that's been filed against you. You're on a Class A misdemeanor assault as of June 4th, 2025. You were charged here originally with the second degree felony of assault on a peace officer, and then it was reduced to a Class A misdemeanor assault, and that was in June of this year. And there's a DWI. This states you committed driving while intoxicated on October 21st. So that was about 3 or 4 months later. And then also you failed to never become intoxicated by being under an influence of some intoxicating substance on that day, which is a different condition of probation that is alleged you violated. Failed to provide verification of performing community service hours as required, and failing to abstain from the use of any and all intoxicating substances. Those are all different conditions of probation that it is alleged you committed, and it looks like from that event in October. So we're going to have a motion hearing on this as soon as possible. I'd like this set for next week if possible.
You can be out, lab results back here.
Okay.
We just want a bond.
I want a hearing as soon as possible. When can we get those back, do you think?
I'll need to, I'll have to contact the agency.
Did they do one? I mean, they took, I guess,
Did they do a blood test?
something from them.
Evidently there was a blood test.
Okay, what are you asking for?
A bond.
Okay, what's state state?
Blood was collected to go back to answer
Okay.
that question.
If we can get that hastened, that'd be nice. Because I don't want the motions have been.
As of right now, I cannot speak as to timing because I didn't know that this is the direction it was headed. I'll have to contact the agency and find out, Your Honor, where we're at with that. As far as that goes, we can move forward with a hearing if Your Honor wants to do that. I can get the law enforcement agency here. We can work without the case being filed.
Well, I think a lot of it has to do with the results. Huh?
It would.
Okay.
But according to the PC, there's field sobriety tests that were done, and the officer can talk about that. I can prove intoxication without the blood test.
I'd like a blood test. Yeah.
Yes, sir.
Thanks.
Yes, sir.
So, what about the bond? He's just saying a bond, and he's not even descriptive. What are you talking about? I know it is. What are you talking about?
It's deferred. She's entitled to a bond, Your Honor.
Okay, you're going. I'm going to grant a bond of $5,000 in this case, but you cannot operate a motor vehicle. Period. On my watch until we get this resolved. Do you understand?
Yes, sir.
You're going to have some other way of getting around, and then also you. What is it that we want to do for the alcohol? I want to.
Probation officer is suggesting the drop program, Judge.
Oh, she was to install the inner one.
No, I want something else. What else? Prevent from alcohol.
Well, sure. He's not driving. You'd have to be scram. He wanted to do something. She is employed. Were you employed?
Excel group.
doing.
Electrical, yes, sir.
Electrician one. What?
Okay, there was vodka in the center console. Okay. So, we need to get something that, what device?
Device.
The scram device,
All right. And where did she acquire that?
I believe they have one in Liberty. That's the closest.
Okay. And that, how does that work?
It's on around her ankle and it monitors it through her sweat.
Okay, that will be ordered as a condition. We're gonna fix this mess.
All right, just when you get it out, you'll have to get the spray installed and see what the
And
bottom.
Liberty.
I don't know where it'd be going.
Goes on your copy on the shed.
You'll see that. It's not dry.
This was the last of October.
Maybe I could come tomorrow. Tomorrow.
We get back to work.
Yes, sir.
Very difficult without being able to drive, but try.
That's easier. We can see.
You can't operate a motor vehicle until we can get this disposed of.
That's just talks with it still.
And we'll set this for a motion to revoke hearing as soon as possible. I have Reginald Allison.
That's also a volunteer.
Same thing here.
That's more. What?
See how old he is. I go every time.
You said Derek Lewis to drug court, is it right? Off the trial of it? Or he's in drug court?
Right.
Lewis.
So who's here for Mr. Boyd?
Same for the judge.
Or do y'all want to go with that one? How's he doing on probation?
This is Mr. Allison.
Yes, Chair.
Reginald.
Other than this new charge that he picked up back in September, he's current on fees and reports as directed, Your Honor. And he still has incomplete CSR hours and that's positive THC and opiates.
We're asking for reasonable bonds, Your Honor.
I represent you before.
But I'm not sure. That's Mr. Michael Laird. If you remember, if he ever represented you.
I think it was like more like your dad or.
That's probably my dad.
Yeah, I think so.